Good morning, ladies and gentlemen. On behalf of the High Court of Manipur, I extend a very warm welcome
to all the distinguished dignitaries, learned members of the bar, officers of the registry, invited guests, and participants to the lecture series on criminal law. May I request the registry official, Shri Ojesh Mutum, Registrar General, and Shri K.H. Ajit Singh, Registrar Judicial, and the learned advocate, Pushpa Gurmayum, Secretary of High Court Bar Association of Manipur, and Advocate Bisheshwari to kindly escort the dignitaries to the dais. We are honored to have with us Honorable Mr. Justice Sanjay Carol, Judge, Supreme Court of India, Honorable Mr. Justice N. Kotiswar Singh, Judge, Supreme Court of India. Honorable Mr. Justice M. Sundar, Chief Justice, High Court of Manipur. Honorable Mr. Justice A. Bimol Singh, Judge, High Court of Manipur. Honorable Mr. Justice A. Guneshwar Sharma, Judge, High Court of Manipur. Honorable Mrs. Justice Golmei Gaiphulshillu Kabui, Director of Manipur Judicial Academy. Shri Lenin Hijam, Advocate General of Manipur. Shri S. Brajabihari Singh, Chairman of Bar Council of Manipur. Shri N. Kumarjit Singh, President of High Court Bar Association of Manipur. Shri C. H. Bimol Chandra Singh, President of All Manipur Bar Association. We are also honored to have with us Honorable Mr. Justice M. Nirmal Kumar, Judge, Madras High Court. Honorable Mr. Justice P. N. Prakash, former Judge, Madras High Court. Shri E. Chandrasekaran, Advocate and Special Public Prosecutor for NIA, Madras High Court. We shall now proceed with the felicitation of our esteemed dignitaries as a mark of respect and gratitude. May I now request our Honorable Chief Justice, Honorable Mr. Justice M. Sundar, Chief Justice, High Court of Manipur, to kindly felicitate Honorable Mr. Justice Sanjay Karol, Judge, Supreme Court of India. I request the Honorable Judges of High Court of Manipur, Justice A. Bimol Singh and Mr. Justice A. Guneshwar Sharma, and Honorable Mr. Justice M. Sundar, Chief Justice, High Court of Manipur, to kindly present the Ras Leela painting to Justice M. Sanjay Karol, Judge, Supreme Court of India. May I respectfully request Honorable Mr. Justice M. Sundar, Chief Justice, High Court of Manipur, to also felicitate Honorable Mr. Justice N. Kotiswar Singh, Judge, Supreme Court of India. Thank you. May I request Honorable Mr. Justice A. Bimol Singh, Judge, High Court of Manipur, to kindly felicitate Honorable Mr. Justice M. Sundar, Chief Justice, High Court of Manipur. May I request Shri Ojes Mutum, Registrar General, to kindly felicitate Honorable Mr. Justice A. Bimol Singh, Judge, High Court of Manipur. Thank you, sir. May I now request Shri K.H. Ajit Singh, Registrar Judicial, to kindly felicitate Honorable Mr. Justice A. Guneshwar Sharma, Judge, High Court of Manipur. May I request now Srimati Monalisa Maibam, Registrar Vigilance, to kindly felicitate Honorable Mrs. Justice Golmei Gaiphulshillu, Director of Manipur Judicial Academy. Thank you, ma'am. May I now request Shri K. Nirojit, Registrar of Translator Wing, to kindly felicitate Shri Lenin Hijam, Advocate General of Manipur. Thank you, sir. May I request Shri S. Joychan Singh, Registrar of Admin, to kindly felicitate Shri S. Brajabihari Singh, Chairman of Bar Council of Manipur. Thank you, sir. May I now request Srimati Mayang Lambam Chanu Nandini, Joint Registrar Finance, to kindly felicitate Shri N. Kumarjit Singh, President of High Court Bar Association of Manipur. Thank you, ma'am. May I now request Shri Sheikh Asif Shah, Deputy Registrar Judicial, to kindly felicitate Shri C.H. Bimol Chandra Singh, President of All Manipur Bar Association. Thank you, sir. May I respectfully request Shri Ojesh Matum, Registrar General, to kindly felicitate the dignitaries on the extended dais. Honorable Mr. Justice M. Nirmal Kumar, Judge of Madras High Court. Honorable Mr. Justice P.N. Prakash. May I now request Shri K.H. Ajit Singh, Registrar Judicial, to felicitate Shri Rajendra Narayan Das, IPS, IG, MNN Sector, CRPF. And to also felicitate Shri Rajendra Prasad, IPS, DIG, MNN Sector, CRPF. Thank you. We now move to the ceremonial lighting of the lamp. May I respectfully invite all the dignitaries to the dais to kindly proceed for the lamp lighting. Thank you. May I now respectfully invite Honorable Mr. Justice M. Sundar, Chief Justice, High Court of Manipur, who is also a functional president of today's program, to kindly deliver us the welcome address.
Honorable Mr. Justice Sanjay Karol, Judge, Supreme Court of India, Honorable Mr. Justice N. Kotiswar Singh, Judge, Supreme Court of India, Honorable Mr. Justice M. Nirmal Kumar, Judge, Madras High Court, Honorable Mr. Justice A. Bimol Singh, Honorable Mr. Justice A. Guneshwar Sharma, Judges of the High Court of Manipur, Honorable Justice Golmei, former Judge, High Court of Manipur and Director, Manipur Judicial Academy, Shri Lenin Hijam, Advocate General, State of Manipur, Shri S. Brajabihari Singh, Chairman, Bar Council of Manipur, Shri N. Kumarjit Singh, President, High Court Bar Association of Manipur, Shri Bimol Chandra Singh, President, All Manipur Bar Association, Shri Ojesh Mutum, Registrar General, High Court of Manipur, all the registrars, officers, staff of this registry who are present here today, members of the bar, all judicial officers, Mr. R.N. Das, Inspector General, CRPF, Manipur and Nagaland, Mr. Nidhi Shivare, Additional SP, NIA, L. Bilashini Chanu, Scientific Officer from the Forensic Department, and all those who have joined us virtually and other attendees. We have others in other part of the High Court here, sitting in Court Hall number 5. They are all here. All the 9 judicial districts are here. It's a pan-Manipur presence today. A very good morning to all of you. It is a distinct honor and a privilege to welcome you all today to the inauguration of our special lecture series on criminal laws, which is a precursor program to the 13th Foundation Day celebrations of High Court of Manipur, which will be on 23rd March 2026. I should also welcome press and media who are here, the Fourth Estate, covering this event. Most welcome. The purpose of this lecture is to bridge the gap between theoretical legal provisions and their practical application. Over the coming working sessions, we will delve into intricacies of new criminal laws, exploring everything from digital evidence to revised procedural safeguards to ensure that we as a legal community are equipped to navigate this evolving landscape. I, on behalf of High Court of Manipur, extend a warm and respectful welcome to Honorable Mr. Justice Sanjay Karol, Judge, Supreme Court of India. We look forward to your special address, which we are sure will be of immense guidance to a young High Court. Welcome, sir. High Court of Manipur and entire state of Manipur are proud of Honorable Mr. Justice Kotiswar Singh. I welcome you, sir. We look forward to your keynote address, which I'm sure will be a source of inspiration. it would be more appropriate for me to thank Justice Kotiswar Singh than to welcome him. He is son of the soil. Thank you, sir, for gracing the occasion, though it is a welcome address. We are exceptionally fortunate to have with us today Honorable Mr. Justice M. Nirmal Kumar, who will be guiding our first session. And a little later, we will have Justice P.N. Prakash, a former judge of the Madras High Court, and Mr. E. Chandrasekharan, who is a special public prosecutor for NIA, who will be joining us, who are not here. They've landed, they're here in Manipur. They'll be joining us shortly. I welcome Justice M. Nirmal Kumar, who is very, very well versed in criminal trial. Please make full use of the resource person is the request I would make to those in the gallery. I welcome all the judicial officers, members of the bar, and law students. I welcome all the participants, and I urge you to be more than just listeners. Criminal law demands critical inquiry. Please use this platform to ask questions, challenge assumptions, and engage profoundly with the material. Though part of the host team, I welcome Registrar General, registrars, officers and staff of the High Court of Manipur and Manipur Judicial Academy who have worked tirelessly to make this event a reality. I am certain that the next few hours will be intellectually stimulating and professionally enriching. Once again, a very warm welcome to everyone. Thank you.
Thank you, my Lord. Ladies and gentlemen, it is my profound honor to welcome Honorable Mr. Justice N. Kotiswar Singh, Judge, Supreme Court of India. Justice Kotiswar is born in Imphal, Manipur. His lordship completed his education in Delhi and began his legal career in 1986. He practiced extensively before the High Court of Guwahati High Court and served as Advocate General of Manipur before being elevated to the bench in 2011. He went on to serve as a judge of Guwahati High Court, Chief Justice of High Court of Jammu and Kashmir and Ladakh, and was elevated to the Supreme Court of India in July 2024. His remarkable journey reflects deep commitment to justice and constitutional value. May I now respectfully invite Honorable Mr. Justice N. Kotiswar Singh to kindly deliver the special address.
A very good morning to everybody present here. Namaskar, Vanakkam, Kurumjari, Mayam Punumapu. Honorable Justice Sanjay Karol ji, my esteemed senior brother and colleague in the Supreme Court of India, with whom I have been sitting in the Supreme Court for a fairly long period of time, from whom I have learned so much also. Honorable Justice, Chief Justice M. Sundar, Chief Justice of Manipur High Court. Honorable Mr. Justice A. Bimol Singh, Judge, Manipur High Court. Honorable Justice A. Guneshwar Sharma, Judge, Manipur High Court. Honorable Mrs. Justice Golmei, who was adorning the bench till very recently, now has taken over as the Director of the Judicial Academy. The Learned Advocate General, Mr. Lenin Singh. The Chairman of the Bar Council, Mr. S. Brajabihari Singh. The President of the High Court Bar Association of Manipur, Shri N. Kumarjit Singh. Shri C.H. Bimol Chandra Singh, President of the All Manipur Bar Association. Honorable Justice Nirmal ji, who is amongst us, and senior advocates of the High Court, Manipur, other lawyers, my dear students, and also I'm now that from the CRPF also, and NIA also, officers are here, and my dear students. It is always, I feel, humbled being invited by the High Court of Manipur, having been part of this High Court since its inception. And we are going to see the 13th foundation also on the 23rd of March. But unfortunately, that being a working day, so there was some difficulty on the part of us, especially who are from outside, who are not present in the state to attend. And Honorable Chief Justice Sundar ji has been very kind enough, gracious to kick-start the process in anticipation of the Foundation Day of which will be going to be organized on 23rd of March. As I stand before you, I must pay my homage and respect to all those others, doyens of the bar, who had adorned the bench as well as contributed immensely in the legal growth of the state, who are no more amongst us, who continue to guide us with their knowledge, the skill which they had transmitted to us when we were young lawyers. And I can see a large number of young lawyers and the law students who are going to be the future of the legal structure, the entire legal our community of the nation. So with that homage to the departed soul, I'd like to speak a few words. I will not take much of your time because we have assembled a very learned members of a legal fraternity. Honorable Justice Nirmal Kumar Singh, he has mentioned by the Chief Justice also, has begun his career as a criminal lawyer who is known for his skill, knowledge and expertise in the criminal law, which is so important, especially in our part of the country, in the state. And we will also have Justice P.N. Prakash. I am told he has already arrived. He was a judge of the Madras High Court. He is also another excellent lawyer who had he is known for his skill and knowledge in the law criminal field, as well as I am told Justice E. Chandrasekharan himself also a person of great knowledge and the skill in the field of criminal law. So we have three very important speakers who will be addressing you on various aspects of the criminal law. Law is such a vast subject. There is no end to the knowledge of law. Right from the colleges where we taught law, in our journey as a lawyer, young lawyers, as a senior lawyers, as a judge, not in the High Court, but in the Supreme Court, is a constant learning of law. Because the law evolves. Law is nothing but the reflection of the experience of life. Law is not just mere academic syllabus or some knowledge which is taught in the classrooms. Is much more than that, because it's the application of the law principles which you have been taught in the colleges, which you have learned in our practice, to the actual problems of life. When a person is arrested, what is the safeguards of a person who is arrested? Constitutional safeguards. How the lawyers has to prepare himself to defend his precious right, the fundamental right, and how a judge has to adjudicate, how to balance the right, the fundamental right and human right, and the interest of the state, the security of the state, the all balancing act, all constant assessment one has to make. Nature, depending on the nature of the gravity of the offense have been charged of, so and so forth. What I am trying to say is that law is a dynamic, constantly evolving dynamics, for which we must be, first of course, fully grounded on the principles, the basic fundamentals of law. Once we have the fundamentals of law clear in our mind, how do we apply in the constantly changing scenario of our community, our society life, is the real how to apply. That's the real skill which is going to be taught by these experienced persons in the field of law. And coming to the students, I am very happy that the Chief Justice ensured that the students of law are also part of, because you are going to join very soon. I can tell you one thing, that in India, law is not merely a kind of the last option. In our times, law was not really the favored subject. People used to go for engineering, people used to go for medicine and other UPSC, all kind of services which are available. So only it was kind of last option, or those who are really interested to become a lawyer. But today, what we're seeing, that there is a huge surge of interest among some of the best students, brilliant students. They are applying through CLAT, Common Law Entrance. I think that CLAT, I think you must have applied also through that. You can get into some of the best universities in the country. There is so much of competition to enter this, to get the education itself. Now there are about 1 lakh students who are passing out from in this country. There are about more than 15,000, if I am not mistaken, law colleges and universities in this country. So what I'm trying to say is that law is becoming an intensely competitive subject. It is just not that you all wish to join law, some kind of hobby or something. No, it is becoming an intensely competitive subject. Not only that, law is becoming intensely complicated. Earlier, in our time, there used to be a civil lawyer, criminal lawyer. That's an odd person who is engaged in company, corporate lawyer. These are the broad distinctions. Now that there is no more such distinction today. We have, just say in the criminal law, you have cybers, you have PMLA, you have NSA, detention, preventive detention. Various kinds of criminal law statutes have been now created, for which you require an intense understanding of the specialized laws. Similarly, in the field of civil law, is no more restricted to mere mutation or domestic issues or property laws. Huge arenas, they have IPR, intellectual property rights, trademark, infringement, all various, then commerce. Huge expansion in all aspects of law. But in spite of all this diversification and the complexity of law which has evolved today, but the basic fundamentals of law remains. Whether in criminal law, whether in civil law, fundamentals of law have to be the basis for any or endeavor in any specialized law. Therefore, I would request especially my students who are here also and the young lawyers that get the fundamentals cleared. And as far as today's session is concerned, this is not going to be the only one. This is just a beginning. I'm sure under the active guidance of the Chief Justice, some more programs will be arranged in various aspects of law also. Because law is constantly evolving. We have constantly, for the judiciary, as far as judiciary is concerned, we have Judicial Academy. We are training these judges constantly, but unfortunately for lawyers, that we don't have a systematic or organized, institutionalized method of training the lawyers. So it will kind of haphazard, kind of ad hocism, which is being, and this is what, but then this is an opportunity where not only the lawyers, judges, but also lawyers will be part in this entire exercise. As law, there are certain things, especially for my law students and the young lawyers. Apart from the knowledge of law, hard work, dedication, perseverance, tenacity, discipline, these are some of the virtues you have to inculcate. You have to start practicing these virtues, because law is like a marathon race. It is not a 100-meter sprint. You just run for 100 meters and you can get a gold medal. Marathon race, you have to run for years. It's a big challenge. There may be situation in the initial stage, you may feel depressed that you are not getting the client, you are not getting money, how do I survive? That's a basic question. Especially those first generation lawyers who do not have their relatives or friends as seniors to guide you. How do you do that? They're a big challenge. But don't be depressed. You should not have any reason to be disappointed. Today, there are see, for example, if you see YouTube, and I have realized that YouTube also can be a great source of knowledge. Any subject you want to see, and there are very wonderful speakers, lawyers, judges, retired judges, who are giving lectures on various aspects of law. You utilize that experience apart from attending these kind of seminars, and organizing these kind of seminars requires a huge effort from the institution, time, money. But then it may not be possible to organize this kind of seminars so frequently. Therefore, you have this this opportunity to learn from others through digital media. That's one of the important things which I think the students and lawyers have to keep in mind. We have to take advantage of the digital infrastructure which have been provided. We are entering to an era of AI, artificial intelligence. We must keep ourselves abreast with the development going thick and fast in this country. We should not be detained by the fact that we are staying in a landlocked place. The distance between Manipur and other parts of the country is huge, expensive. But that should not detain, that should not disappoint us. In today's world, digital world, you can reach out to any part of the country, any part of the world, for the purpose of gaining knowledge. Yes, I mentioned about AI also. Having practice in Manipur, in fact, I started my practice, though I studied in Delhi, my graduation, both before I joined law, graduation in law and other subject, basic BA, honors in political science, then I went to, took up this law. And a few months, about less than a year, I was in Supreme Court and High Courts in Delhi. But essentially, I started practicing here in Manipur, there where I learned the art of cross-examination, observing our seniors who were doing that. Fortunately, at that time, we were part of the Guwahati High Court. So because of paucity of judges, the judges would come once, I think weekly or bi-weekly in a month. So what would happen is that would give an opportunity for us to practice both in High Court and the lower court. In lower court, whenever the High Court is sitting, we'll shift our practice in the High Court, and now again, whenever the High Court is not there, then we'll go to the lower court. That's how all of us, my senior colleagues, my colleagues, friends here, senior lawyers here, we are all together practicing in that manner. Learned the art, the art of pleading, art of cross-examination, submission in the court. These are possible. And the fact that I became a judge, that judges, honorable judges are sitting here also, and I'm sure in due course also those who have the opportunity, time, they will be elevated. Manipur has to produce such talents because we have the potential. But we must make sure that we utilize the opportunity which we are getting here. Unfortunately, because of certain disturbances in the recent past, the development, there has been a slow growth in that development. In spite of that, I'm so happy to see that we are able to organize this function, and we have reached out to all the 9 districts. I was the Chief Justice also just mentioned also, we have reached out to all the 9 districts, judicial districts, through the medium of the video conferencing. This knowledge sharing must continue, update ourselves. And if we are determined, if we are consistent, if we are dedicated, success is bound to follow. I will not take much of the time. All I can say, wish you all the best. Please take, I am sure some of the best minds here, legal minds here, will be addressing you. Please do not hesitate to ask questions. Because only the interactive session will make you understand any situation better. Sometimes we feel that if we ask some question, it will expose our ignorance. But the whole exercise is to clear those doubts, ignorance. If you are already enlightened in this and well versed in law, there was no reason for this kind of interaction. And apart from that, even if you know, there is no harm in learning the experience in other jurisdictions. How it has been explained, how it works in other jurisdictions, because it will always enrich our knowledge and skill in the discipline. There is no point restricting our knowledge and experience only of this place. We must learn how it is practiced in other parts of the. That's why it is so important that the external, the resource persons come from other jurisdictions also. When we share our knowledge, experiences, it enriches our experience. Therefore, I would request that you be more proactive and participative in the sessions that is going to follow. Yes, there are a few things also, of course, I want to say that the legal profession is perhaps one of the most important pillars, foundation, which sustains this society, which is based on rule of law. There was a time when a society, whenever they lagged behind in education and economic development, would be dominated by more powerful, economically powerful societies. That's why we saw colonialism. If we study the history of colonialism, the West could dominate the world because of the industrial revolution which took place, the technological advancement which has taken place. That's how they could subdue and dominate the rest of the world. Now today, there is a form of domination which is going to take place by those powers who are powerful in the field of artificial intelligence. The world is going to be dominated by artificial intelligence. We have already seen in practice, even in battlefields, the Operation Sundar, the Indian intelligence had a huge role to play. It was not mere jets and the cannons or firepower which decided. It's the intelligent use and intelligent use of the resources of the country. I'm talking of this. The other areas also, in all other fields, AI is changing the landscape. It is going to change the landscape in the legal field also. I would therefore request all my students, young lawyers, that we must equip ourselves better in the digital world, especially in the legal field. We must acquaint ourselves, because if we lag behind in this, we'll be left behind by the others. This is a new area of challenge. I'm sure there will be an occasion to deal with this cyber and digital issue in some other time. In fact, only last week we had a symposium, seminar organized by the Rajasthan Legal Services Authority on the whole issue of cyber crime, cyber safety, the digital world, the Act, Data Protection Act of 2023, and the data protection rules which have been framed in 2025. We must equip ourselves. This is a new law, and this is something, wherever you are, one can always learn this subject. And in fact, cyber threat is one of the greatest challenges before in our legal system. All of us, whether you are in Manipur, Bengal, Delhi, Bombay, Calcutta, wherever it is, the kind of cyber crime which is occurring is a kind of similar pattern, how people are falling prey to this cyber arrest, digital arrest, and cyber frauds which are taking place. and the enemies of the country also trying to influence our people through the means of digital means. It is a big challenge before us, certainly for the law enforcing agencies. And the students of law and who are practicing not only as a lawyer but judges, the time has come to equip ourselves in this very well in this field. So this is cyber is a law, digital law is something which I would love to emphasize upon in our subsequent training sessions. And of course, as I mentioned earlier also, the options for the lawyers is opening up like anything else. As I mentioned, various subjects have been introduced, the various fields of specialized laws have come. The new introduction is of the mediation. I'll be very happy if there be a special session also in mediation. We have our Mediation Act of 2023. The rules have been framed also. And what is the scope of mediation? Because it will reduce the burden of the common man. And apart from reducing the burden, it will lead to a resolution of the problems in a most amicable manner, not in an adversarial manner, adversarial law which we are so used to. So these are some areas we have to equip ourselves, have more better understanding, so that ultimately, because our state unfortunately has been a conflict-ridden society. Since the time we were born, and when we became aware, this problem has started. It continues. We can't live in a state of conflict. We can't live in an environment of confrontation, because that will be hindering any progress. You can't have progress when there is a conflict. Simple as that. History of mankind teaches us. We have not seen any society progressing with conflicts all around. Only a society which is peaceful, which has time to settle, think, ponder, has progress. And you can't have the time to think, ponder, when you constantly are afraid of your life, constantly trying to look after your property, your life. In that state of tension, in that state of, anxiety, you can't have peace. If there is no peace, there cannot be progress. And we in the legal profession, in the lawyers, the judges, have a huge responsibility to ensure that peace is brought in this society. If we do not have peace, we are going to be left behind. Nobody is going to do anything for us. Today's world is a sometimes very competitive world. In this is a kind of, sometimes one can be a little bit pessimistic saying that might is right. I am not saying that. But if you are weak, nobody will look after you. We have to look ourselves. Some people can give an extending, helping hand to us, but ultimately we have to stand on our own feet. It is very important for us, therefore, that not only we learn also, but we also make sure that the peace and stability in the society returns, without which the society cannot progress. We will be at the mercy of the more powerful, dominant groups. So my request to all other stakeholders, I have no say on that, but as far as the legal profession is concerned, we must all unitedly work together to strengthen the rule of law, because without rule of law, there cannot be democracy. Without democracy, there can be progress. Thank you very much, and wish you all the best.
Thank you, Lordship, for the deeply enriching address. Distinguished guests, ladies and gentlemen, we are also deeply honored to have with us our chief guest for today's program, Honorable Mr. Justice Sanjay Karol, Judge, Supreme Court of India. Justice Karol hailed from Garli in Himachal Pradesh, completed his education at St. Edward's Schools, Shimla, and Himachal Pradesh University. After a distinguished practice before the High Court and in Delhi, he served as an Advocate General of Himachal Pradesh and was designated as a senior advocate. Elevated to the bench in 2007 as a judge of Himachal Pradesh High Court. His Lordship went on to serve as Chief Justice of the Tripura High Court and later the Patna High Court. before his elevation to Supreme Court of India in February 2023. Today, he will be sharing his valuable insight on the theme, Relationship between Bar and Bench. May I now respectfully invite Honorable Mr. Justice Sanjay Karol to deliver the Chief Guest address.
Very good morning to all of you on the dais and off the dais, ladies and gentlemen. My esteemed colleague, Honorable Justice Kotiswar Singh, Chief Justice Shri and Sundar, Guest of Honor Shri Justice Bimol Singh, Justice Guneshwar Sharma, Justice Golmei, Learned Advocate General Shri Hijam, Chairman Bar Council of Manipur Shri Singh, President of the High Court Bar Association Kumarjit Singh, President of All Manipur Bar Association Shri Singh, my colleague Honorable Justice Nirmal Kumar, and the director from the forces, young students. How do I begin? Honestly, I'm not quite sure, because I'm overwhelmed, emotionally surcharged. When I landed at the airport, my wife was with me, and I told her that I go back to my memory of 2018. And that is the time when I entered the territory of that part of India, which was totally alien to me. I was to take oath as Chief Justice of the Tripura High Court in November 2018, and I saw the stark resemblance between Tripura and Manipur. But what was really exhilarating was that when all the officers, judicial and the state officers, officers from the judiciary and the state were there. So when I was taken to one of the rooms in the airport, I asked them, how do you maintain yourself? You look so young. You are always having a smiling face, and you emit so much of energy that I can see every cell of my body vibrating. My compliments to each one of you, residents of the state of Manipur, the judicial officers who were there, and thank you, Chief Justice, I was received well. I must also say this, that I come home, so I need not be welcomed. On the contrary, I must welcome all of you. My experience in Tripura has been that, and I've been traveling from Tripura to the northeast quite often, that people of this region, of this great nation, are more nationalistic and patriotic than any part of India. Pardon me, Chief Justice. I also correlate myself with this state because I come from a hilly state, come from Himachal Pradesh, Shimla. The geography more or less is the same. Traditions, culture is of course different. But it gives me immense pleasure to be part of you in this inaugural session of the lecture series. Friends, and especially the young students who are up there, and those who are connected through the video conferencing mode, let me share this with you, that when we read Article 39A, I'm only reminded of one thing, and that is that both you and I, when we are talking of you and I mean those who are engaged in the justice delivery system, be it on this side or that side, and those who are in the executive, the forces, the administration. We have only one duty, one purpose, and one object, and that is to uphold the constitution and the constitutional spirit. And it takes me back to remind myself of what is there in the preamble of Constitution, and that is, we the people of India have to ensure that justice, be it social, political, or in whichever form you may call it, including other essential ingredients, is lived every moment by each one of us. And we together come forward to protect and preserve the integrity, sovereignty, and unity of this great nation. Honorable Justice Kotiswar and the Chief Justice mentioned as to what our duties are and how do we have to live it up. I will only say this, that when the Constituent Assembly sat to frame this great document, the Constitution of India, we had approximately 348 members. And out of those 348 members, we had approximately about 285 advocates, practicing advocates. So lawyers have a great role, have always been having a great role in the development of this nation, be it in the preparation of the document, legislation subsequent legislations, or their interpretation. I must also say this, that when I say we, means the lawyers and the judges, and also the executive, we are the custodians and guardians of this great document. And we have a duty to ensure, and we shall work together to take this great nation to much greater, to further greater heights. Our role, so to say, is supportive and collaborative. We have to make sure that the nation progresses in every aspect of the matter, be it economic or otherwise. My Lord Honorable Justice Kotiswar mentioned about the happiness. You know, I'll tell you, we both experiment one thing in our court, and that is that whenever a matter comes to us, we tell every litigant, it is very easy for us to adjudicate a matter, but that doesn't render justice. Justice is when both the parties go back happy, contented, that yes, we have been heard, we have been listened, and our viewpoint has been taken care of. And if in endeavor, with the endeavor or the bench and the bar, the matter is resolved amicably, then it is a win-win situation for all. For it brings happiness, contentment, joyfulness at home, in the community, in the neighborhood, in the state, and ultimately it raises the happiness quotient of the nation. And taking forward what I have said just now is this, that our role is not adversarial in taking the nation to strides. We sit here to only see that the constitutional spirit or the text, letter in spirit, is not transgressed by anyone, including ourselves. When the executive, political or otherwise, takes certain measures which we find are not within the permissible or even stretchable limits of the Constitution, then we do take remedial measures. Otherwise, both of us, all of us, have to work in unison, is what my view is, and I would implore upon you to work in that side. Ultimately, each one of us have got a stake in democracy. And democracy is not only political freedom. Democracy is also social and economic freedom. Freedom from what have been shackled all along for centuries. When Honorable Justice Kotiswar guides me in the court, he tells me one thing. The litigant who comes to the court, quite often we call the parties, be it the officers or be it the litigants. We allow them to speak. We experiment a lot of things. Because our system is such that first time we find that the person behind this entire litigation or behind this system has got to speak for the first time. He is satisfied immensely when we allow him 2, 3, 5 minutes to open up what he intends to say. For the first time, he gets opportunity to speak. That gives him great satisfaction. That A, he has a face. 2, he has been heard. And 3, someone has listened to him in his own language. And the results are phenomenally successful. And that is precisely what the officers, when they come and communicate to us, that they have been heard, we have heard their point of view, and then they take appropriate measures, corrective at that, whenever it is required. As far as bar and bench is concerned, let us tell you, sir, ladies and gentlemen, that we are wheels of the same chariot, both working in unison, in symphony with each other, and only with one purpose and object. The purpose being to wipe out the tears of last and the least and the marginalized one. We do have, as I often remind myself, two Indias. That's a reality. One is the metrocentric reality, metros, and the urban is, and the second is the mass rural India. Our approach, this I say from my experience, from Himachal Pradesh, I came to Tripura, from Tripura I came to Bihar, and now I am there serving the nation from Delhi. I realized that the real India, the aspirations, the aspirants are there in the rural areas. So we have to, when we talk of rendering justice, we have to think it from their perspective and not from the perspective of what a person sitting in the metro area, in the cities and metros feel like. So we have to work with compassion, to passionately with compassion to achieve what is there in the Constitution. I would also say this, that the biggest, my Lord spoke about artificial intelligence. I would just add here one thing, that most testing times came for us during COVID as an institution. And COVID is one time when adversity was converted into an opportunity. And how did that opportunity come? That is using the tools and the technology in transforming lives. We take pride in the fact that the Indian judiciary stood up to the times. Nowhere in the world did you have the justice delivery system available to the teeming million citizens of this country. Nowhere in the world. It's an example which was set up by the Indian judiciary through a digital mode. Access to justice, what is there in Article 39A, was ensured. We made sure, each one of us, wherever we were, that doors of the justice, be it for providing food, be it for ensuring that the women, their voices of the ladies and children is not gone unheard and unheeded, made sure of all this. I do remember in Bihar, 40 lakh migrants coming back from cities, and they were all holed up in small rooms. Now imagine a person who is exposed to the vagaries and the systems and the vices of a metro, coming back to a rural area, and the biggest trauma which had to be suffered was by the women at home and the children at home. So we made sure that their voices were heard. Special teams were constituted to visit almost every taluk and see that whatever is required to be done is done in accordance with law. it gave me an opportunity, personally speaking, and this is my advice to each one of the judicial officers. The district judge has this great advantage of traveling the entire district. The Chief Judicial Magistrate also has this advantage of, and because he has authority to travel anywhere, any territory and cover any territory of his jurisdiction. The Chief Justice also has that advantage. Tripura, there were 8 districts chief. Going back to Tripura, we were just 3, just as you are 3 here. We were just 3 of us. I was just inquiring from Honorable the Chief here, what is the total pendency of the High Court? I had in Tripura about 3,800 cases at that time when I went, almost same. My pendency in the district courts was almost 60,000. So for me it became a big challenge how to reduce that pendency. And with this active support of the bar and my family, my judicial officers, we were able to bring it down by 40,000. In Bihar, I had the good fortune of traveling all 543 subdivisions and 38 districts, not once but twice. But that gave me an insight of what really rural India is. And that gave me an insight as to why litigation in Bihar, illustratively I am giving an example, has increased. And that gave me an insight to study the demographic profile of not only of the people but also the litigation. So I found, I don't know, I'm not sure here, but we are talking of the criminal justice delivery system, that 10% of the matters were of pendency was of civil in nature, and 90% were criminal nature. So I asked myself, why is it that crime rate is so high there? And the answer lied only on 2 things. One, that the civil disputes not being adjudicated led to the criminal dispute, led to crime. For every one civil dispute, there were multiple criminal litigations. One reason. Second reason is delay in the trials of criminal matters. So immediately we took measures and lok adalats or issued directions to see that the civil litigation comes to an end, and simultaneously wherever the criminal trial was procrastinated, delayed, 30 years, 40 years criminal trials not being progressed. So they were immediately taken up on priority and trials concluded. 3 years gave me remarkable results, and those were that the criminal litigation started coming low. So when we talk of criminal adjudication of matters, we may only say this, that please ensure that the trial is not delayed. Because one thing is there, criminal only worries about one thing. A hardened criminal doesn't mind going to jail. That's my experience. He will have multiple cases, he will go behind bars, but he will be released ultimately But once when he is convicted in accordance with law, then he knows that is the end of his criminal activity. So, expeditious trials is perhaps the key and the message, in fact, I want to give to the members of the bar and bench here. I would also say this, my Lord has already spoken about the challenges of the artificial intelligence. But I would say that with the use of technology, media trials are taking place and the judges are defenseless. They have no voice, save and except for that the voice of the judge is the bar. I do remember Justice Kanya, when Mr. Setalvad, when the Supreme Court was started functioning, so Mr. Setalvad expressed the hope that the court, and I'm reading, would earn reverence through truth, and that it would be assisted by a strong, well-equipped and independent bar. To which Justice Kanya replied, and he reminded the nation that no court can perform the duties satisfactorily unless assisted by a strong, intelligent and industrious bar. And that is how our republic was born. Let me tell you one thing, that there is no distance between the bar and the bench. And let me also say this, and I say it with a lot of conviction, that judges are neither celebrities nor gods. They are here only to serve the nation in whatever manner and capacity and potential, to their optimum potential. Bar can help promote justice delivery system, and the chairman is here, the president is here. We do experiments, sir, on daily basis. Young members of the bar are being promoted. What we as judges are doing, we are just only giving you examples. And we implore upon the members of the bar and also the students to do a lot of pro bono work. And what is that work which you have to do? And that pro bono work is on nothing. In continuation of Article 39A, to see that we reach out to those who are left out of the justice delivery system. As per the data, almost 95% of the citizens of this great nation have no access to justice. Out of 140 crores, almost 50% of the population are women. Now, do women really have their voice? Are they familiar with the justice, with the justice delivery system? Are we not to reach out to them, to their homes, to their villages, apprise them of their rights, listen to them, and do whatever is required for them? One example I will give you. When we started engaging the students and the lawyer community in this pro bono work, there is one district in Himachal Pradesh, it is known as Kullu. Now in Kullu, we found that suddenly we were with our activity of educating the people. And we found that suddenly there was spurt of matrimonial cases. So we had got a study conducted as to why is it that suddenly there is a spurt of matrimonial cases, divorce cases. And we realized that divorce for them meant only going to the court and the notary public on a stamp paper, just typing out and typing out that they have been divorced with a seal of notarial seal. That's about all. But when we went and reached out to the villages, informed them that what really divorce is, because multiple issues of inheritance and paternity arose. So then people were educated and they got to know what really the procedure is. Similarly, I don't know how many of you have been to Simla, but if you can just search on the net, you will find that the first experiment with the police forces was conducted by the Legal Services Authority of having an open prison, and that being that life convicts who had reformed themselves and were part of the society and there was no apprehension of their fleeing away or violating the law. They had opened up a bookshop and a cafe which was run from the famous place which we call in Simla as the Ridge. It was one of the great experiences that led to the NALSA adopting this program. I would also say this, that the young members of the bar, when you will come to enter the profession, you are one of those fortunate ones. My Lord Honorable Justice Kotiswar said that when we were there, it was only just coming to court and setting up our practice. But you have great options today. You can be a teacher, you can be an influencer, a new term which I learned, that now lawyers have become influencers. You can be a blog writer, you can be a journalist, and you can be anything that you want to do to pursue the law and ensure justice delivery system picks up its pace for the reaching out to the marginalized ones and rendering justice. I would also say this, that Chief, when I came here, there was an attendant which is of course deputed with every attendant of the court, from the court, which is deputed with every dignitary who comes. It has smiling face. So when we are talking of our relationship with bar and bench, members of the bar, let me remind you that we have munshis. And as judges, let us remind ourselves that we have class, I don't know, whatever nomenclature you call it here, but 4 and 3 staff. So they are part and parcel of our family. We have to take care of them. One illustration I'll give you that in Bihar I had the good opportunity of, because new establishments are coming up. So there was a big space which was to be utilized for which was where houses were to be constructed for the entire staff, class 1 to class 4. So and why I am saying this, because every day we live the Constitution, and I was only trying to apply the Constitution. So when it came to the class 1 officers, the state had provided for a modular kitchen. I myself went and inspected what is there for class 4 peons. And it was one room accommodation, that's about all. So I told them that for them also you will have to provide modular kitchens. For 2 months the deliberations went on between the executive and the administration of the state. And the executive would not budge till the time the Chief Justice and the Chief Minister had to intervene. And when I told the Chief Minister inquired, why is it that we are meeting? So I told him, to put it in Hindi, that समाजवाद का ही issue है, is nothing but equality. That's about all. And I am firmly of this belief. Now I am told, as was my belief then, that the modular kitchens being there, it has transformed the lives of those who came to live in those houses from shanties. Their whole mindset of their children and the new generation has opened up. And this is really what Constitution is, and this is really what is there in the preamble. We have to bring freedom, which is an equality, which is not only political but social and economic. I would also say this, members of the bar, that the honor and the dignity of the judge and the strength, in fact, lies in the bar. The real prestige of the judge comes from the bar. We have seen testing and trying times in the last 76 years, that the bar has always stood in times of necessity and need with the judge and judiciary. I would also say this, that when we write judgments, a judge is known by his judgments. Is it or is it not? I would say something else. A good judgment comes only if it is supported by a submission from the bar, which helps the judge write a judgment which is sound, full of reason and logic. I would also say this, that a well-meaning bar can help transform the judge and the justice delivery system. I went to Tripura and I was pleasantly surprised to find every lawyer there well equipped with the library. My experience, my first introduction with the field of law, let me tell you, ladies and gentlemen, was when I I used to go to my grandfather's office, my maternal grandfather's office, find a whole library, his office full of library. He was a lawyer, senior advocate. So he would have volumes of Halsbury's and All England there. So my grandmother, my nani, maternal grandmother, I was very young at that time, so she would tell me, when we would go to our village, we would find, what do you call here, I'm not sure, but flying foxes, chimgadar. I don't know what you call them here, they're flying foxes only. So she would tell me always that never become a lawyer. I said, why? Because in your next birth, he will be flying fox. You inverted backwards. I said, why? But why would I become a flying fox in my next birth? Because the lawyers tell lies. So that was my first introduction to law as a child. But I realized one thing, that this is such a noble profession. And never ever, children to you, I don't remember, and God forgive me, that I have had to tell lies to anyone in this profession. This is one profession where you are the king. You don't have to tell lie. You have to be truthful. You can be truthful to the extent of filing your income tax returns, true income tax returns. And yet, you can be extremely, extremely successful. Because this is one profession which, unlike any other profession, or I would say there is no other profession to that of this profession, where not only you are the king and you can achieve success, but you can live life king size. Because at the top, it's plateau. It is not a pyramid. And you are your own competitor. There is none else in this world other than you who can take you to greater heights. I was talking of the judgments. A judge is known by the judgments he writes. Is it so? I would put it like this. The judge is known as how good a human being you have been. And unless and until you are a good human being, in my considered view, you cannot deliver justice, because you cannot distinguish what is just, difference between just, fair and reasonable. Two yardsticks in the Supreme Court we adopt. My Lord Kotiswar would correct me. That first is, two of the best of our judgment, we see that no injustice is caused to anyone. That's the first yardstick. And when we come to the conclusion that our opinion is not rendering any injustice to anyone, then the second yardstick which we adopt is this, that there should be broad substantial justice. If it is there, who has come to the last court, the last of the hope, can we not wipe out his tears? And when we are talking of compassion, I am only reminded of what Kardzu had to write in his book. And Kardzu the opening sentence is this. He quotes the Bible. He says, Jesus said, "Let my justice be guided with compassion." So this is what we always keep in our mind. And this is what I would implore upon you, that we must all strive to take this great nation to yet greater heights, increase the happiness quotient. A new term which I think I have coined it, I have not copied it, and taken to greater heights. I would also say this, that the young lawyers, you are the future of this great nation, and work as hard as you can. Manipur is a great state. People of Manipur, as I said, I found them smiling, full of energy, vibrating. I hope I will take a lot from this visit. And Chief, let me say this, that whenever you want me to be here, for whatever purpose, be it in the capital or in the suburbs, I will always be available for you. Always and always. Thank you. Jai Hind.
Thank you, Lordship, for enlightening us with your address and gracing today's program with your presence. Before we proceed for a vote of thanks, we would like to take the opportunity to kindly felicitate the dignitaries seated on the extended dais. I request Shri Guneshwar, Registrar General, to kindly felicitate Honorable Mr. Justice M. Nirmal Kumar, Judge, Madras High Court. Extended dais. To also felicitate Honorable Mr. Justice P. N. Prakash, former Judge, Madras High Court. To felicitate Shri E. Chandrasekaran, Advocate, Special Public Prosecutor for NIA, Madras High Court. Thank you. We have now come to the concluding segment of the inaugural session. I would like to kindly invite Shri Guneshwar, Registrar General, to kindly deliver the vote of thanks. And I request everyone to kindly stand right after the vote of thanks, as national anthem will be played right after.
May it please my lords, distinguished members of the bar, esteemed colleagues, learned officers, and dear participants, students, members of the press, both print, electronic media, ladies and gentlemen. It's my proud privilege to rise and propose the vote of thanks at the conclusion of this inaugural session of the lecture series on criminal laws, organized as a curtain raiser to the 13th Foundation Day of our High Court. At the outset, I respectfully place on record our deepest gratitude to the Chief Guest Hon'ble Mr. Justice Sanjay Karol, Judge, Supreme Court of India. My Lord's gracious presence has truly adorned this occasion. My Lord's address on relationship between bar and bench was both reflective and forward-looking, reminding us that the strength in the justice delivery system lies in the mutual trust, intellectual honesty, and fidelity to our core constitutional values, my Lord. We are equally honored to have amongst us Honorable Mr. Justice N. Kotiswar Singh, Judge, Supreme Court of India. My Lord's homecoming presence is a source of inspiration, particularly to the law students and young members of the legal fraternity assembled here today, reinforcing the message that commitment, scholarship, and integrity in the profession can take one to the highest constitutional office. I convey our sincere thanks to my Lord Justice M. Sundar, Honorable Chief Justice, High Court of Manipur, for conceptualizing and guiding this lecture series. My Lord, it reflects a deep constitutional commitment to continuous learning and to strengthen the criminal justice delivery system through informed dialogues. I also respectfully acknowledge and thank all the honorable guests of honors and dignitaries on and off the dais who have come to grace this occasion. Your meaningful presence here today amplifies the unity and shared responsibility of the bar and bench and other key stakeholders in nurturing professional excellence and standards. Our heartfelt appreciation goes to the learned resource persons, Honorable Mr. Justice M. Nirmal Kumar, Judge, Madras High Court, Honorable Mr. Justice P.N. Prakash, former Judge, Madras High Court, and Shri E. Chandrasekharan, Special NIA Prosecutor at Madras High Court, who have all flew in from Tamil Nadu on such a short notice. Sirs, your noble commitment to this occasion to share the scholarly and practical insights on such topics of seminal essence is greatly appreciated, and we are all eagerly looking forward to your esteemed deliberations in technical sessions. I also extend a very warm thanks to the galaxy of key stakeholders across the spectrum, the members of the bar, law students, judicial officers, public prosecutors, investigating officers, legal aid defense counsel, and officers from paramilitary forces and central agencies, whom I sincerely believe will bring vibrancy to the technical sessions through thoughtful interactions. I must also place on record our sincere appreciation for the members of the Fourth Estate, the media fraternity who is covering this program, thereby playing a responsible and informed role of bridging the gap between the institutions and the public. Finally, I would be remiss in my duty not to express gratitude to the officers and staff of the High Court and the Manipur Judicial Academy, whose quite dedicated efforts have ensured the seamless conduct of today's program. With profound respect to all present, I conclude by thanking each one of you for making this inaugural session meaningful and memorable. Thank you.
Please rise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे, गाहे तव जय गाथा। जन गण मंगलदायक जय हे भारत भाग्य विधाता। जय हे जय हे जय हे, जय 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 हे।
With this, we have come to the conclusion of the lecture series of criminal laws, requesting the protocol team to kindly escort the dignitaries and senior advocates for Haiti, and requesting all the participants to kindly partake it right in front of the auditorium. Yes, and I request everyone to reassemble right after we will be starting 12. We will start the technical session by 12 p.m. Thank you.
ꯀꯩꯅꯣꯗꯤ ꯂꯩꯔꯕ ꯄ꯭ꯔꯦꯖꯦꯟꯇꯦꯇꯔꯗ ꯑꯩꯈꯣꯏꯒꯤꯗꯣ ꯑꯅꯤ ꯁꯨꯕꯅꯤ ꯁꯨꯁꯦꯜ
हाँ हेलो एक ज़्यादा है हेलो हेलो
हेलो हेलो हेलो हेलो
ये आ जाए
PPT शेयर वो जो वायरलेस माइक्रोफोन भी रेडी है
हेलो 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 ये दोनों है ना हेलो हाँ हाँ इसमें एक पे नया वाला है और एक काला है
हेलो हेलो
हेलो हेलो हेलो
हेलो
हेलो हेलो हेलो हेलो हेलो हेलो हेलो हेलो हेलो हेलो हेलो हेलो भाई बस पंचा हो रही
हेलो हेलो
हेलो
हेलो हेलो हेलो
हेलो हेलो हेलो हेलो
हेलो हेलो
यहाँ पर जाना होगा ना तो यहाँ करके ये तो ऐसा डालेगा
माने हेलो हेलो ओ यार अच्छा
हेलो हेलो हेलो
हेलो यार यार
हेलो
ये पहले ऐसा नहीं हुआ था
क्योंकि वो ये लगा है ना
कन्वर्टर हाँ पे यूज है
हेलो
हेलो
हेलो हेलो हेलो
हेलो किन आएगा
ये कौन सा नंबर क्या है इसका माइक्रोफोन का?
कौन सा ये आगे
पोडियम का।
पोडियम का तो ये वाला है हम ये कर रहे हैं टास्क कर ओह कैसा है ठीक है ये दो है
ये वाला साउंड इधर भी ले सकते हैं जब चार माइक फोन कर रहे हैं
हेलो 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 चेक 1 2 3 हेलो चेक 1 हेलो 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 कम हो गया हेलो हेलो हाँ हेलो हेलो ज़्यादा हो गया हेलो हेलो कम हेलो 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 चेक हेलो 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 चेक हेलो चेक हेलो 1 2 3 हेलो 1 2 3 हेलो 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 1 2 3 हेलो 1 2 3 हेलो 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 हाँ अभी नॉइस हाँ हेलो 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 1 2 3 4 5 हेलो हेलो चेक हेलो चेक हेलो चेक चेक हेलो 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 चेक हेलो हेलो चेक चेक हेलो चेक हाँ इसका ये हेलो हेलो चेक हेलो 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 चेक हेलो 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 चेक हेलो 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 चेक हेलो 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 चेक ओके
हेलो हेलो चेक 1 2 3 चेक हेलो दोनों चाहिए आ रहा हेलो 1 2 3 यार नंद्रे हाँ हेलो 1 2 3
हेलो
माइक हमिंग सॉन्ग चेकिंग हेलो 1 2 3 और माइक से सीगी डिस्टेंस अदो Testing 1 2. Testing 1 2. Hello, testing 1 2. Testing 1 2. 1 2. Testing 1 2 3. Testing 1 2 3. Hello, 1 2 3. Testing 1 2 3.
Hello, 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 hello. Hello, one, hello. Hello, check, hello. Hello, check. Check. Check.
Hello, testing 1 2 3. Hello, testing 1 2 3. 2 3. Hello, testing 1 2 1 2 3 4 5. 1 2 3 4 5. Hello. Testing 1 2 3 4 5. 1 2 3 4 5. Testing 1 2 3 4 5. Testing 1 2 3 4 5. Testing 1 2 3 4 5. Hello, 1 2 3 4 5. Yadra. 1 2 3 4 5. Mic testing. Jawab dong, Sir.
that?
So you have PowerPoint.
Do you have the PowerPoint? Yes, I've already sent it. No, I've already sent to you.
Okay. Sushil, Kamala. PowerPoint to the camera. We don't have. So.
You don't have?
Yeah.
I already yesterday sent.
Sir, who is one?
Which one?
This one, sir.
Yesterday we did it. Yesterday, no? Yeah, yes, this one. Yes. Yes.
Sa ay na di high graban eh. High graban ba?
All the participants are requested to reassemble right now. So the program is about to start.
Hello. Sorry, this is the next.
Which one?
This is the forward and this is the...
This is backward, this is forward.
Yeah.
Yes, we have started. Everybody assembled.
Losip, kindly sit for a while. We will introduce something about you also. And after that, I will call Bishop. I repeat again, all the participants, please reassemble here.
ममांगी सीट सिंह जे हाइदे छात्र के मखा कुमदा हल हां मखा दने हां कुमदा हल अजे छात्र ओ या ला नम मणिपुर दा
मथक फंबीरीब स्टूडेंट सिंह हाइदि ngahak हाइदि मखादा नखोय खरा लापियु ना हाइदि सिट सोम ममांगी फ्रंट की हांगी जिंगजिदा
Code number 5 to label so no words.
Code number 5.
No student 5. So we start.
Code room number 5 te yawiriba participants singju haidi auditorium hall da lakpina ba haidi khara
Yeah. Librarian. Hello. 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 Yeah, read you the thumbs.
ยัง
Good afternoon, everyone, one and all present here. It is my distinct honor, privilege to extend a warm and cordial welcome to all the dignitaries, esteemed resource persons, distinguished guests, respected participants assembled here today. On behalf of the High Court of Manipur and the Judicial Academy, I wholeheartedly welcome you all on this lecture series on criminal laws, organized as a precursor to the 13th Foundation Day celebration of High Court of Manipur. We are immensely pleased to commend this year's academic engagement with this significant program. For today's technical sessions, we are deeply privileged to have with us eminent jurists and distinguished scholars whose contribution to the field of criminal law are both noteworthy and exemplary. It is my proud privilege to introduce Honorable Lordship, Mr. Justice M. Nirmal Kumar, Judge of the Madras High Court. Thank you, Lordship. His Lordship was born on 23rd November 1965. Lordship has completed his 5-year integrated Bachelor of Laws degree at Dr. Ambedkar Government Law College, affiliated to the University of Madras. Enrolled as an advocate in 1989, his Lordship has over 25 years of distinguished experience at the bar, handling a wide spectrum of matters, including criminal law, Prevention of Corruption Act cases, Prevention of Money Laundering Act matters, cybercrime, human rights, consumer protections, customs, NDPS, and mines and mineral laws. Lordship has appeared in numerous high-profile cases and complex cases. His Lordship was elevated as a Judge of the Madras High Court in the year 2018. In today's first technical session, His Lordship will enlighten us on the topic, nuances of criminal law. We are pleased to note that more than 750 participants have registered for this lecture series, attending through both online and offline modes. In view of the overwhelming response, arrangements have also been made for a live telecast in courtroom number 5 to ensure the smooth conduct of the program. To begin the first technical session, may I now request Honorable Lordship Mr. Justice M. Nirmal Kumar, Judge Madras High Court, to kindly deliver the technical session. Thank you, ma'am.
I have to use the cursor here only, no?
Yeah, yes. This is a PPT, Lordship. This is a PPT.
I think Mr. Oje should have updated it. But the contents would be on
Can you try me?
but I gave you something. Vojesh must have changed the thing.
I think this one is the final one. The nonsense of criminal.
Nuances
Is it
of
not
criminal
working
trial.
from here? Is it not working from here? From this remote? Final is this one is the final one. Also, he's fixing right now.
He's fixing. This is my.
Final है क्या? Final है प्राप्त. Final में कम नहीं है.
Hello.
Final से वहीं जाओ. Hello. Sir, season sir, थारक खुदा तो मर गया.
This is a same PPT on Lordship. Is it not working? Thank you much.
Thank you. Good afternoon to one and all. The topic is nuances of criminal trial. We all know trial is the foundational basis based on which a case is decided. Hence, trial to be uniform, transparent, and the prescribed procedure to be followed, imposing confidence to both accused and the victim. CRPC, earlier and now BNSS, is a procedure, gives guidelines to proceed when complaint is received. When complaint gives a guideline to proceed when the complaint is received and report to be filed. In cases of cognizable offences, the duty is cast upon. You have a more. Duty is cast upon the investigating officer. Put it in the pocket. Put it in the pocket.
In this pocket, sir.
Any pocket. Duty is cast upon the investigating officer to immediately act on the information, visit the scene of occurrence, inquire the witnesses, present there, record their statements, collect materials available in the scene, take steps to apprehend the suspect or accused, all the collected materials to be forwarded to the jurisdictional magistrate without any delay. If the detention of the accused is required, steps to apprehend him and produce him for remand. We all know, as per section 57, it has to be done on the same day. This is 24 hours. If it's going to go beyond 24 hours, then we have to come back to section 167, and thereafter the police custody, and he has to be remanded. And for further inquiry with the accused or suspect, you can ask for a police custody. Previously, it was 15 days, that is within the first remand of 15 days, police custody has to be taken. Now, after BNSS, the amendment has been brought in, the provision is that within the period of filing this charge sheet, be it is going to be 10 years or less, it's going to be 60 days. If it's going to be more than that, it's going to be 90 days. Within the period of 90 days or 60 days, as the case may be, anytime you can take for police custody. That is the changed position. And the code contemplates the procedure how, under what circumstances, the person who is an accused is an offense to be inquired, detained, arrested, produced before the magistrate for remand. For some, it might look it's from the starting stage because some students are there. You all have to understand how the criminal procedure code acts and how a case is brought. A criminal case is brought to the police station, thereafter how investigation is being done. On completion of investigation, how it is filed before the concerned, either it's going to be a magistrate court or special court or any other court, how the charge sheet is being filed, and thereafter trial proceeds. So each step I have to explain so that it will be easy for you to understand. Wherever the victim is injured, when a victim is injured, basically criminal offenses are two in nature. One is on bodily offenses, one is on the documents and other things. And now this is the basic concept of criminal offenses. One is body and another is with regard to documents and other forgery and other things. But recently, after the internet and after the COVID period, after we start using a lot of internet and onlines, this cyber crime has now taken an important role. That will come later. So now we have three types of offenses. One is bodily injury, one is on the records and documents, and third is on cyber crime. Wherever, as regards the physical injury, bodily injury, the victim to be referred to a medical practitioner and medical records to be collected in case of bodily offenses. That is, what I say is, once immediately the injured person has to be referred to the hospital. There, hospital, the casualty doctor or the doctor who treats it, receives the patient, immediately gives medical treatment. In that situation, one important factor is AR copy, that is accident register. One accident register record will be maintained by the doctors, and that accident register in which it will be stated that whether who had brought the injured, whether the offense has been informed to the police, and what an appearance, what are the injuries found, and have 2 lines or small gist about the injured or the person accompanying to state about how the injury has taken place, where, place and time. So this will be the first document with regard to the bodily injury cases where the doctor takes, and this accident register will play an important role in deciding a case, because doctor is a third person who is neither interested in for the injured person to get justice or to get a punishment to the accused person or who is the offender. So this document plays an important role because that is the first document and initial document which is recorded. And thereafter, victim, in cases of victim is a minor, lady, mentally or physically disabled person, victim to be produced before a magistrate to record 164(5) statement. This is the next stage where the victim is a minor or a girl, so that the magistrate records the statement and that becomes an important document. 160. Now I am referring to, all I am referring is only CRPC because that I am very conversant and I have been practicing and I have been doing it. But take it from me, there is no much major difference between CRPC and BNSS. BNSS, what the important factors, what I could so far understand is that electronic evidence has been given important role, where the recording of statements, confessions, or preparation of mahasars, where video audio can be done and that will be taken into evidence. That is in BNSS. And furthermore, in BNSS, yet another factor is that timeline has been given, within which period investigation to be completed, within which period it has to be filed before the magistrate has to complete the trial. And once you file a charge sheet, within which period you can file a discharge petition after receiving the copies. These are the basic timelines and other things which has been given in BNSS. Otherwise, in sum and substance, CRPC and BNSS are almost on the identical plan. And only after the introduction of BNSS, fresh cases have been filed. Those cases only has to be proceeded in under the BNSS. Otherwise, everything to be in CRPC, which has to be continued, either being investigation or being trial. So the recording of the victim statement before the magistrate has to be done. In the scene of occurrence, or from the accused, or from the witness, or from the victim, any bloodstained materials, weapons found in the scene of occurrence is collected, seized, and the same has to be sent to the serologist. Serologist is the person who studies the blood grouping. So this blood grouping will have an important aspect, important role, because if in the weapon or in the dress of the victim, if there is a blood grouping or blood grouping found, of the accused is found there, then it confirms that accused was present there. For that no reason, accused blood grouping has to be found along in the cloth of the victim. For these purposes, and victim was wearing the dress at that point of time, and it was used at that point of time for finding out and confirming the same. This serologist report is important. And in case of rape, vaginal swabs and other materials are collected from the victim to find out the presence of collected and sent to swab test to find out about the confirmation of the rape and presence of sperms and other things. In case of pregnancy where baby is delivered or fetus is removed forcibly, then DNA test has to be conducted. This DNA test is conducted to confirm the parentage or the person who is the reason for the birth of the baby or for the fetus. And DNA test, take it from me, 99.9% it is to be taken as proved. There is no way other than that to take. Once DNA test comes confirming that this is the person who has come, is the reason for this pregnancy or the fetus, then straight away, without going into other aspects, conviction can be given. And in case of collection of internal organs like liver, kidney, intestine, spleen, these, when the doctor conducts a postmortem, collects these articles and send it to forensic examination. This is sent for forensic examination. This is what they say is viscera. If you go into it, viscera. This viscera is an important factor to find out presence of poison. If the person has committed suicide or by way of death is due to poison, then to find out presence of poison, these things are collected and viscera report is collected. That report will confirm the presence of poison. And postmortem report is very much necessary, be it a case of murder, accidental death, or suspicious death, whatever may be. If there is a death which is have got some suspicious something, postmortem is very much important to find out the postmortem doctor examines the body physically first and find out, notes down the injuries found apparently. Thereafter, post-autopsy is conducted. During the autopsy, the internal organs, the injuries, the corresponding, suppose there will be a stab injury, to how far it has traveled inside to the body, those things, those aspects will be recorded in the postmortem report. And postmortem report is an important document to find out the reason and the cause of death. And the opinion of the doctor will be, normally cause of death is excessive bleeding, shock, hemorrhage, and due to the injury sustained, suppose it's going to be blunt weapon used, hitting on the head, forehead or back, those things are all on the injury sustained on the skull. If it's going to be a drowning, it will be saying that due to the drowning, or if it is going to be hanging, due to the hanging suffocation sustained, and also this mark, neck mark will be given. So for those aspects, postmortem report is a very, very important document. Be it going to be an ordinary motor accident case, case of drowning, and with regard to attack using weapons. So postmortem report is base document or a primary document in case of death. And With regard to postmortem also will give the drowning, whether it is accidental drowning or after the person has been killed, thereafter the body is pushed into the pond. For that, the important factor will be diatom test. One diatom test will be done. The diatom test is a test which will give to find out whether water is inside the lung, which has gone into the passage, it is available in the lung. So in case of drowning, the investigating officers not only to collect the body from the concerned pond, they also have to collect the water of the pond. So that water has to be compared with the water, suppose water is found inside the lungs, which has to be compared, and it has to be found. Say that it is drowning, or if no water, nothing is there, then it is earlier by smothering or something, murder has been committed, and thereafter body has been pushed inside, to rule out that. And in case of use of firearms, then ballistic expert report has to be obtained. Yes. When it comes to, that is with regard to the bodily injuries. Now, with regard to the document-based offences. When it comes to offences involving forgery of document, forgery can be either forging your signature, forging the document itself, and a document may be genuine, but with false particulars, then also it becomes a forgery. Otherwise, the document on the face of it, the stamp paper or any document might be genuine, but if the contents of it is with false particulars, false document, then also it's a forgery. So when you find a forgery, which is common in cases of sometimes in check, pronotes or documents, wills, so many and so forth, forgery is there. In that cases, when you want to assess, find out the forgery, whether the signature or writing is forged or not, then it has to be sent to the handwriting expert. For sending a document, before sending a document to a handwriting expert, the important thing is to collect the signature or writing from the accused person or other persons who are used the document or at some point of time dealt with the document, and not only collecting the specimen signature writings, and you must also collect the admitted writings. Admitted writings over the same point of time might have been written in a letter or some other document, some other things would have been written. So those things have to be collected, because comparative of handwriting or signature involves study of disputed signature with standard signature, not specimen. That is a big difference. Specimen, at that point of time, when the police is inquiring, you are asked. But the document which has been forged or signature which has been forged must be years before. So there might be some variations. And there might be also by force asked to trace out the same thing what is found in the forgery. To rule out that, you have to first collect the specimen along with the admitted signatures or writings, draw out the standard signature. Then that standard signature or writing has to be compared with the disputed signature or writing. Then only the forgery has to be found out. This is for this, we all know section 45 of the Evidence Act. Section 45 of the Evidence Act not only speaks about handwriting expert, it speaks about expert. Whatever be it, whatever field it may be. Section 45 speaks about the expert. So whatever document or disputed has been collected is being sent to the expert for getting his report. Yet another way of finding out the forgery or studying the forgery is section 73. But that is preferably not followed, because that finding has to be given by the trial judge or the court. That Supreme Court has time and again said that it is better to refrain, not the presiding officer not to give an opinion. That is there. And with regard to, as trial lawyers, and trial lawyers, trial judicial officers, trial court judicial officers. The other aspects of the other offences will be Food Adulteration Act, which comes to the Magistrate Court, and Drug and Cosmetic Acts. The major difference between Food Adulteration Act and Drug and Cosmetics Acts will be that it will not be prosecuted by the police. It is not like regular case, filing an FIR, investigating, filing a charge sheet. It will be the public servant will register a complaint, will collect he'll go to the, either it's going to be, when it's going to be food alteration, to the hotel or any eatery or any other place, and if it's going to be there, he goes there, finds that, suspects that this food item is an adulterated or unfit for human consumption. He will pay money, collect 3 samples, one will be retained with him, one will be sent to the court, and one will be sent to the analyst. And the analyst will study and give a report. There is a timeline given, how to collect the samples, when to send, and how fast it has to be sent to the analyst. That is with regard to food alteration. The same thing, almost similar, applies to Drug and Cosmetics Acts, where the drug inspector visits the medical shop or the medical godown or the manufacturing place of medicines, finds that this drug is not as per the specification or some doubt is there, they will seize the articles. In that case, 4 samples has to be seized. Again, the same principle, and all the samples has to be sent, 2 has to be retained and 2 has to be sent for analysis. In both the cases, central analysis laboratory is there. When a report from the central analysis laboratory is received, that laboratory has got the primacy, it is said to be conclusive proof. And with regard to food alteration and drugs and cosmetics, when it is, and the procedure for the prosecution in food alteration and drug and cosmetics is that the drug inspector or the food inspector will, after concluding, collecting the details, he will file by way of a complaint before the concerned magistrate. That is the major difference between the police filing a charge sheet and a public servant filing a complaint. What is the difference is the procedure itself varies. In the private complaint other than police report, normally in CRPC there will be a chapter saying that private complaint other than a police report. That has to be followed here, and if it has been followed, then the complaint evidence witnesses completely has to be taken afresh before the court, and after they are recording their statement, then thereafter option will be given to the accused person whether to cross-examine then and there or wait till the charge sheet is, charges are framed, and thereafter, after framing of charges, the witness will be again called. It's a long and a laborious process, but that is the way it has been framed. And with regard to charges and the importance of charges, nuance, Senior Brother Mr. PNP will be taking up the class in the afternoon with regard to the charges. In that, this difference also will be informed. And when it comes to Narcotics, Drugs and Psychotropic Substance Act, we normally call it as, shortly call it as NDPS Act. NDPS Act, there are procedures which are strictly to be followed since the punishment is severe. It starts from, except for small quantity, 3 years, and all other quantities, be it intermediary quantity or the commercial quantity, it is 10 years, 20 years, and life. So NDPS, the primary reason is once the investigating officer or a person, government servant who has been authorized to investigate, gets an information about the narcotics being smuggled, transported, or concealed, he immediately writes down, whatever information he gets, he put it down in writing, and he submits to his immediate superior that this is the information from this person. Some basic contents has to be given, this information, and give it to superior. Thereafter, after getting approval from the superior, informing the superior, then he proceeds to the place where the information has been got about the scene of occurrence, There, along with his team, they go. If suspect is found, identified, suspect is called, he has been informed about the information, whatever he has collected. This is the information against you. We suspect that you are holding or concealing or transporting narcotics. And thereafter, he will be given an option whether he can be searched before a magistrate or a gazetted officer. And thereafter, if you say, normally they record that, he will say that, no, I've got confidence with the investigating officer, you yourself and search me. Then search is conducted. If anything which is concealed in his body or from him, after getting information, the article is found, the contraband is seized there, and immediately in the scene you have to prepare a mahasar with regard to seizure. And straight away it has to be deposited in the Malkana, and everything has to be properly documented. And samples now, after Mohanlal case, samples has to be taken before the magistrate. 52A samples has to be taken before the magistrate, and thereafter the samples will be sent to the forensic to find out what is the nature of the drug which has been, narcotic or psychotropic substance which has been seized. And the person who is investigating has to send a report to a superior officer under section 57. So section 42, 43, 50, 52A, 57 are both directory and in some cases and also mandatory. Whatever may be the investigation, after filing of this, after completion of investigation, the final report, either it's going to be a negative report or a positive report as charge sheet, it has to be filed before the concerned magistrate court or before the concerned special court or before a magistrate court, and thereafter the magistrate finds that it is a sessions offence, he will commit it to Court of Sessions. And as far as special court is concerned, special courts, there is no procedure of committal. It can be straight away filed before the concerned special court. Special courts, namely for NDBS Act cases, SC/ST Act cases, POCSO Act cases, those cases and all are tried by the special court. This is the overall idea of it. Now, when an information has been received by the police, how an FIR has to be registered under what section? Registration of FIR under section 154 of CRPC, which is identical to section 173, where the police mandatorily to register an FIR under once the information discloses a cognizable offence, and it can be registered by police station on receiving the information by complainant in writing or through online. Now, with regard to this is under BNSS, that online facility has been given, and zero FIR allowing the registration and to be filed, and police cannot refuse to register an FIR. And further, a copy must be provided free of cost to the informant. When an information about an offence has been received through email or other electronic means, the informant, in cases, because this you normally get in online fraud or any other social media offences where the person is outside but something has got, immediately they can send it to them, police can act, but it has to be followed by the informant to come to the police station and give it in writing. And these are the decisions, landmark decisions with regard to registration of the FIR, how police has to do it. That is Lalita Kumari case. And with regard to FIR should be uploaded online within 24 hours. Arrest after FIR must follow due process, Arnish Kumar case. And with regard to quashing of FIR, you have Bhajanlal case and impact of delay in filing FIR, and only one FIR could be registered for a single offence. This normally happens if you see that if it's going to be in a financial fraud, like chit fund cases, or chit fund case, or some any scheme or anything. Several persons would have been the depositors, or several persons would have invested the money. But one person would have come and given already lodged a complaint. But other subscribers also will be there, maybe it will even run to hundreds, thousands. They will come and give a complaint and saying that I also deposited with the X company, I have also been cheated. For each of the persons, you not need to put an FIR, register an FIR, one after another, then it will be multiplicity of the cases. So what they do, what they say is, as with regard to TT Anthony case, the first information what you get from one person will be registered an FIR. Subsequently, if any other person who is giving a complaint with regard to the same and similar offense, then it can be investigated along in the first case itself, and the person who has given can be added as a witness, and his statement can be recorded in that case itself. So no separate FIR can be registered, so to avoid multiplicity and complications. What moves are moving? These are the guidelines issued in Lalita Kumari case, which is still in force. Registration of FIR is mandatory under section so and so. Commission of cognizable offence and no preliminary inquiry is permissible in such a situation. If information received does not disclose a cognizable offence, but indicates the necessity for an inquiry, a preliminary inquiry may be conducted to ascertain whether cognizable offence is disclosed. And after inquiry discloses commission of a cognizable offence, the FIR to be registered. Cases where preliminary inquiry ends in closing the complaint, a copy of entry of such closure must be supplied to the informant and forthwith and not later than a week, and it must disclose the reason in brief for closing the complaint and not proceeding further. The police officer cannot avoid his duty of registering offences if cognizable offence is disclosed. Again the same thing. The scope of preliminary inquiry is not to verify the veracity or otherwise of the information received, but only to ascertain whether the information reveals any cognizable offence, and as to what type and in which cases preliminary inquiry is to be conducted will depend upon the facts and circumstances of each case, and they are given a category of cases where matrimonial disputes, commercial offences, medical negligence and corruption cases. Matrimonial disputes, we know that whenever there is a matrimonial discard and the bride's family try to implicate all the members of the bridegroom family unnecessarily to avoid such unnecessary inclusion of brother-in-law, sister-in-law who are all staying elsewhere or not at all shared a common house at no point of time, to avoid that. Likewise, commercial offences, whether it has to be seen whether it is purely comes under cheating or whether the deception was at the initial stage or at a later stage, to find out whether it's purely a business dispute or it involves right from the initial stage, at the initial first stage itself that culpability, criminality was there, to find out that. Medical negligence, again, to avoid unnecessary litigation against the doctors. Doctors, you know, they do it's a noble profession, and in case of emergency and exigency, they take them to a doctor, and doctor, if they have the fear of facing a criminal case later, then they will not put their optimum main and they will not do the whatever required treatment to be given. Some treatments or certain treatments, broadly treatments will be one, but certain risky proposition of taking a treatment will be subjective. And so then later you interpret that you have taken this, taken that because of that this person had that calamity or he had died. Then no doctor will and you ask a doctor, because at that point of time it's going to be an medical emergency, be it an accident or somebody taking serious ill at home. You rush them. At that time you want everything to be ruled out and take. By the time they, even in a heart attack, the 2 hours is the time which is the magic time and the important time to save a life. Likewise, in a stroke, it is 6 hours. So these time factor is also important. At that time, you cannot expect doctors to get all the things ruled out, get it signed, and thereafter to proceed in treatment. Then it will be a difficulty. For that reason, to avoid that. And likewise, in corruption cases, there might be corruption cases, but if a person is aggrieved about what he has been denied of some application or some license he has want to get, or he has got some animosity against the elected representative, or is a rival party, or for various reasons there might be something, the personal egos and ethos should not be a reason for lodging unnecessary corruption cases. For that reason, and that too, there they say that this inquiry to be done within a period of 7 days and find out. Seldom it is followed, but preliminary inquiry has to be followed, and within 7 days they have to find out whether the complaint needs further progress, the case to be registered, investigated. And general diary, station diary, and daily diary is the record of all information. You all know, as a trial lawyer, as a lawyer, advocate, in a police case, these are the 3 important documents you have to see. Because a police, once he registers an FIR, thereafter he goes to the scene of occurrence, registers, investigates, collects documents, and records everything, whatever is collected. Whatever he does in part of the investigation, those things are recorded. That is called case diary. That is what we call as CD. This case diary, as a defense lawyer, as an you are not entitled to look into it. But it has to be then and there recorded. It has to be there. But the court can always call for it, and it can be recorded. Look into the allegation. If suppose if you have got the defense, as a defense lawyer, you have got a tangible material to show that the CD has been fabricated, or some insertions have been made, some corrections have been made, and what he is deposing in the court is contrary to the CD. In such circumstances, you can ask the concerned presiding officer, judge, so that the judge may look into the CD. But it is not just for asking. You have to make out a case. Make out a case, thereafter you can ask to verify the CD, because CD is an important document. After, in fact, in CRPC amendment, CD, it has been stated that it has to be paginated. It has to be paginated. So the pagination is given only for the reason to show that there has not been no insertion of pages or no extraction, removal of pages. For that reason only paginated. But take it from me, in my experience I have seen, till date, no investigating officer follows this pagination, despite it has been brought in the record. Because it will be convenient for them for other reasons. So pagination, the judicial officers, they are empowered. Judicial officers, because they try, as a magistrate, right from the stage of remand, it has been brought to you. First remand is before you physically. You have to verify whether any bodily injuries are there. You have to inquire the person, and whether he has been given the proper advice about having legal aid, whether he has got an advocate, whether he was detained, whether he was injured. These things are the questions which the remanding magistrate at the first instant has to see. And at that time, the remanding magistrate has got the opportunity to look into the papers. And after each 15 days, they come for extension of remand. When they come for extension of remand, at that time also, the remanding magistrate need not mechanically extend the remand, ask for the case diary, what is the stage. Though they give a remand extension report, they will file. But whether that is true or not, whether that is correct or not, whether it is required or not, unless you call for the CD, you can verify it and find out, yes, the further remand is required, further detention is required. So it is the judges, remanding judges or the magistrates who have got all the power to look into the CD. This is only to safeguard the person to be not to be unnecessarily harassed or unnecessarily detained for some other reason. It doesn't happen in not all cases, but out of your rich experience, you must know certain cases will be, complainant will be on the neck, behind the case, and the investigating officer not conducting the investigation impartially may be forced or influenced. In such cases, the investigating officer, to save them, you have, because it's a person's life and liberty. So that is the place where you have to do it. And one more thing, as presiding judges, as for trial court lawyers, I'll tell you, the point of interaction, point of first encounter by the accused and his family members to vent out their pain and to face the legal system is that place. And there they must feel that all the opportunity has been given, all the safeguard has been done, and everything is there properly taken care. Investigation. Yes, I'm not that all who are brought are falsely fabricated or implicated in a case, but to avoid such things and also to give confidence, either both to the accused, as well, accused in the sense accused and family members, as well as to the victim and family members. It has, proper investigation is being done, and there, everything is being considered properly. Those things, the trial judge and trial lawyers are most important person, vital link, and they have to do their duty properly. That is the first place where you come in interaction. If they have a bad taste, or they feel that they have been let down, or they feel that nothing has been done and it is going in an already decided manner, then they will lose the interest or the faith in even the judicial system itself. So the first phase will be the trial phase. That phase must be proper. Thereafter, yes, you can take it up. This is the important aspect of trial lawyer as well as trial judge. And the trial lawyer, one more important thing is that you will have the access, either filing a memo or giving something, or it all depends upon your relationship with the concerned bench clerk. You can always take the documents, find out, because whatever documents is filed, whatever complaint is given, and whatever magazines, whatever articles have been seized, everything has to be then and there submitted to the magistrate court. There the magistrate, with the seal, with the sign, he will receive it. So to find out whether there has been delay and whether the delay is unexplained, those things as a trial judge, trial lawyers, you have to see. Verify whether the seal and sign is proper, documents, whatever collected, statement, whatever recorded, and reach the court without any delay. This is only to avoid the possibility of tomorrow having an apprehension that something has been doctored or some statement has been corrected. It is not the true statement, it is not the true things. It has been recorded or brought up for the convenience of the persons or parties. To avoid that, this thing is very much important. Then arrest of a person, section 41 CRPC is the state where says how an arrest to be made and what are the provisions. 41A CRPC states that if the investigating officer is not intent to arrest, then he can issue a notice. 41, you can go through it. There are various clauses there, in what circumstances and how an arrest to be made and what are the things to be there. And 41A says that wherever arrest is not required, it can be done. But these two things have been now clubbed together as section 35 of BNSS. And the judgments with regard to arrest, we all know DK Basu case, that is still holds good. Joginder Kumar case, how search conducted in connection with the arrest cannot be arbitrary, need to be properly documented. And Balbir Singh case. Arnesh Kumar case is an important case, which all the criminal trial lawyers must know, read, time and again, and biometric data with regard to recession. This is the right of arrest person. The police personnel to have his name identification, so that if it's going to be arbitrary or force, something has been used to make a representation against him. Arrest memo to be prepared, and arrest person shall be entitled to have his friend or relative informed about his arrest. Aware of the right to have someone being informed of that. The arrestee must be examined at the time of arrest. Every major or minor injury must be recorded. That is the reason I said when the first remand, you have to examine the accused, find out whether injuries are there, and the copies of including memo should be sent to the magistrate. Arrestee must be produced before the magistrate within 24 hours. He must be permitted to meet a lawyer during interrogation. Police control room should be provided. Even during interrogation, the advocate can be present, but not during the entire period of interrogation. Specific time he can be permitted to meet his advocate, so that if any force or anything beyond the scope of law has been done against him, he can complain to his lawyer. Here, Dinesh Kumar case, it says as custody and arrest are not synonymous terms. In every arrest there is custody, but not vice versa. Custody may amount to arrest in certain cases. Physical control, Joginder Kumar, Arnesh Kumar, which we already saw. Yes, then investigation by police. How already I have stated, now with this section, which already I have dealt with. Investigation. Investigation, it's nothing but collection of evidence. That is the basic thing. Statements, how to be done. These are all I have overall in the opening itself I have stated. Now with the section it is there. Search by police officer, how to be done. Search whether the officer has to go, and who are the persons, section 100, 165. If the officer person who cannot go, he can authorize somebody. But only thing is, immediately after the search, it has to be informed to the magistrate, and whatever has been searched, it has been done. Everything has to be, magazine has to be prepared, everything has to be recorded. And this search for a person wrongfully confined, section 97 plays an important role, but we seldom use this section. Section 97 is seldom used. Had section 97 properly understood and used, there is no point of filing HCP, non-statutory custody. Immediately, if a drop of a hat, everybody files an HCP, non-statutory custody petitions, illegally detained, so-and-so detained. If you are able to, if you go to the magistrate, file a section 97 petition, the same relief can be bought. In fact, this, in rare cases, where suppose you make an allegation against the police officer, because HCP they say whether you have gone to the police. In those cases, some magistrates they give, and magistrates also depute their Serasar or somebody to visit the police station, find out whether any illegal detention is there in the police station. 97 is used. 97, if you use it properly, both by the defense advocate as well as by the magistrates, filing of non-statutory HCP can be reduced. And with regard to abduction of females, likewise, missing girl, love affair, those things and all is there. That is again for non-statutory custodies. And power of police officer to seize certain property, that is, if any doubt is caused, surprise check and other things it is normally used. Any articles is found in a suspicious manner and no explanation has been got, the police officer has got the power to seize. But again, they have to seize, but only thing is they have to immediately report to the concerned magistrate about this seizure. Now, what I earlier mentioned, BNSS, about videographing. Bail, you know, regular bail, interim bail and default bail. And interim bail is nothing but anticipatory bail. Regular bail, you get it. And default bail is an important clause. In the important clause, default bail. where charge sheet is not filed within the prescribed period, default bail you are entitled. That the Supreme Court has worded that it is an accrued right which cannot be taken away. But only thing is, on the day of accruement, you have to file a petition. Before filing a petition, after, though it means the right have been accrued, but you have slept over, forgot, left it, and thereafter, in the meantime, charge sheet is filed, that accrued right goes off. So this has to be important, but normally in magistrate courts, I mean, as far as state of Tamil Nadu I have seen, the magistrate on the date of the remand itself, they write, and the 90th day or 60th day, they would have written it below it in a pencil or made a mark of it, so that they know that before this day, charge sheet to be filed. That they do. This is, in courts they do it, but as an advocate for the defense of the accused, you must also have a note of it, so that when the 60 days or 90 days comes, and immediately be alert to file a petition under, for 167(2). Because in heinous crimes and heinous things, by merit you might not get it, but only by default you can get in such cases. And latestly, that Satyendra Kumar, until CBI, brother MMS has given, Supreme Court Judge MMS has given a detailed order. I think this has still not been completely followed, but it has to be followed, which gives a lot of rights to the accused. This I already stated, difference between police report and private complaint. Magistrate power to direct investigation, 153, 156(3), where cognizable offense. This normally, these are the young advocates to make money at the earlier point of your career. It will be a good income source. This you can do that, and guidelines has been given as in Sakri Vasu case, how affidavit has to be filed. Tomorrow they can be published. False information has been given for that aspect. These are the normal, which is normally used, regularly used. 207 for furnishing of copies, 211 framing of charges, and it will be dealt in the afternoon. And section 313 is after completion of investigation. 313 question and answers will be asked. 313 plays an important role, but we seldom, as defense lawyers, they seldom give importance to it. 313, it is, they say that normally most of the time, even the senior advisor will not be there. They will allow the juniors to say, you say false, 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 and sign and come. And when they ask, you say that I got witness to be examined. That is not the case. More so, when it comes for circumstantial evidence, in case of Prevention of Corruption Act, in case of statutory presumption, wherever the offense court statutory presumptions is there, be it POXCO, be it SCST Act, be it 138 case, wherever statutory presumption is there, it is the best place to give your explanation, your defense. Whatever you would have cross-examined, but as a as 313, it's not. We know that by giving a false answer, it's not going, you cannot be prosecuted by not giving. But it plays an important link. When you take a defense, the 313 can be quoted. So 313 is an important aspect which we seldom don't give importance to it. Follow that, and it will be very important. You have to answer it. And 315 again is examining yourself as a defense witness, where the accused person gets into the box. Examining a defense witness is something different. Accused getting into a box and as a defense witness and giving his explanation has got a better weightage, because he comes up, because the section itself will say that he has removed the shield. That is the protection which has been given in the Constitution, where you can keep quiet. That has been removed. You open yourself. But be cautious, it will be suicidal also. But unless you have confidence, unless you know that the witness is strong, maybe he may be innocent, he may be honest, he is not the person who has not committed the offense. But not everybody gets into the box and are able to withstand the drill. So make sure, and thereafter employ 315. And 314 is for written arguments. And these are the important sections. And one important thing, 311 will be there, that is, we always use it. That is the only section which gives power to recall the witness at any stage. But now it has been curtailed to large extent, but still 311 is an important section. And these are the judgments. And since I am running out of time, I am not elaborating much on the other aspects. These are all, I think I'll ask them to give a copy of it so that or send it in the mail to you. You can make use of it. And this is the open quoted sections which I already stated. Again, 340 is an important section, but paucity of time I am not going into it. So wherever false evidence or false documents or perjury has been committed before the trial court or before the court, and you are able to prove it, 340 petition is a very important provision, so that you can put hold on the person who has committed perjury. And 319 is also an important section which the prosecutors must have in mind. Wherever just allow the cross-examination just to go out and think that, oh, he's shifting to somebody person, shifting to somebody person. No. If that is a lead to you, then think over it, find out from the documents whether what he says shifting the other person, some material is there, try to bring it in the other witness, and then thereafter you can file a 319 petition. That is, wherever you skipped or missed, it can be brought into. Criminal investigation under special acts, that is already stated, NDPS Act, POCSO Act. POCSO Act, again, certain guidelines, certain safeguard has been given with regard to who is to, how, when the witness, where the witness to be victim, to be examined by a lady officer, not by having a uniform, videographed, brought to the doctor, produced to the doctor, produced to the magistrate, and within time limit, you have to file and examine the witness without any delay. Those factors are there. POCSO Act. And we are now off late, POCSO Acts are in upswing. And SC/ST Act, again, what are the rights to the victims and how victims have to be informed about the progress of the case at each stage, and pendency of the case, and victims for compensation. Likewise, POCSO Act also compensation. And with regard to refusal of the officer registering an SC/ST Act, he can be proceeded against. Timeline is given to complete the trial in SC/ST Act cases. And victim has to be informed at each stage, be it at the investigation, at the bail stage of investigation, appeal stage, revision stage. At each stage, the victim has to be informed about the pendency of the case. Drugs and cosmetic acts, again taking samples. Prevention of Food Adulteration Act, already I have stated. And other which comes before the magistrate, what the trial judges, trial lawyers, which usually you come across. These are the other cases. Customs Act, RBI Act, Income Tax Act, Central Excise Act, now it is GST, Companies Act, Forest Act, Mines and Minerals, Plantation. These are only illustrative. These are the other acts which normally comes to the magistrate court, which all you have to be there. And now one more important aspect is that NI Act, Negotiable Instrument Acts, are flooding the courts, and that is a good breeding ground for the young lawyers to take up the nuances of the trial. If you don't leave it lightly, try to explore. Don't say that yes, a signature is there, check is there, yes, 118, 139 comes into play, that is all the case. No. Facts can be there. You can also give a rebuttal presumption. It's a good breeding ground, it's a learning process, and it's the magistrate court ensures this will be the breeding ground to find out, to learn the nuance of the trade, your profession, and go by it. Thereafter, you can follow it by the accident cases. Likewise, accident cases, seldom they give importance. Accident cases, you go, motor vehicle accident cases. Again, there you know about the how to cross-examine the motor vehicle inspector, postmortem doctor, eyewitnesses, how to do, and thereafter hurt cases. Slowly you get yourself equipped, graduate, go for sessions trial. And one thing is, as a trial lawyer, I would say that the pleasure and satisfaction you get as a trial lawyer is immense, which cannot be compensated in any manner. Once you win over a witness, the satisfaction you get is you are on the top of the world. But you should not get stagnated in the trial court. Go to the magistrate court, then go to the sessions court. Simultaneously, you also move to the high court because money lies in the high court. Work is there in the trial court, but money lies in the high court. So you equip yourself, move to the high court, and do the profession, and nothing like this profession, and the satisfaction and the pleasure you enjoy, and the pride you carry as an advocate in this profession, in the legal profession, either it be advocate or the judicial officer, the pride of this legal profession, nobody can compensate. As morning they said that previously it was the place of last resort, wherever you don't get engineering, medical college, engineering college, or professional college, then you lastly come to the law college. Now it has turned around, and now getting admission in law colleges has become very difficult. Chartered accountants get law degree, come for law course, engineers come, even doctors come. That is the importance this profession, legal profession, has gained over these years. And take this profession seriously, and you take, this is the only profession, even in Constitution, in Article 21, it says that you can be guided by a legal professional. No other profession finds a place in the Constitution. Your profession, legal profession, finds a place in the Constitution. That is the topmost place the legal profession has been given. And be proud that you are in this profession. Maybe prosecutor, maybe defense advocate, maybe a judge, or so this profession has given you so many things. And as far as the investigating officers are concerned, you are also human beings. Don't kneel down to the pressure of somebody. You collect the documents, go by your conscience, and if you find that there is some link, there is a breakage in the link or some difficulty you are facing, not that in all cases you have to go, everything has to go in the correct time, or within that time you are not unable to do it. Don't try to correct or do some correction or bug it. By the time you feel that within 48 hours it has to reach, but it could not reach for this reason, make a memorandum, put it in writing. For what reason this 12 hours delay, 2 days delay, 24 hours delay, put it in writing, thereafter file it. That explanation will save your case. By small mistake, you will demolish your entire case. So investigating officer also, be honest in your investigation. Not that in every case, if you are unable to reach the timeline, what is the difficulty? Put it by writing. And everything, as far as criminal case is concerned, as an investigating officer, you document everything. You might have it in your mind, it might be in the CD, but it should reflect in the court case, what the documents you are filing in the court. So document it, you document it properly, then nothing, your case will not go defeated. Witness turns hostile or something happens, that is not in your hand. But investigation part of you, whatever is with you, be with conscience and do it, document it properly and file the charge sheet. I think overall time is already there, you'll be feeling lunch. Any questions if you want, you can ask. Yes?
Yeah, not only me, the investigating officers and those who are in the forensic field are in confusion now after the coming of the BNS.
Yes.
Regarding NDPS Act. So while seizing of NDPS Act, is there any necessity for a forensic expert to present on the site, on the scene?
No. Now 50TA Mon law case says that you have to seize it, send it to the Mon. Only thing is, samples to be taken in presence of magistrate.
Yes. So this is the confusion right now running all around in the...
After BNSS, you are much more armed because everything can be recorded in your... There is a software, you can record it in your mobile. That seizure, everything you can record it in the mobile because it is... Then and there it is uploaded. And there is no question of tomorrow causing a doubt and say that it has been tampered with, it has been delayed with.
Even the judiciary is and even the IOs, everyone is having doubt in this regard. That's why I just want to clarify my doubt.
No, it is not that.
Thank you very much. Thank you.
See, you as an investigating officer, madam, as an investigating officer, you carry a test kit which UN has given. UN test kit is given to you. Don't you carry that UN test kit with you?
Of course, as a forensic expert, we are having all the necessary kits.
No, you expert detailed study. You will have a test kit. If you forget you don't have a test kit, by your experience or by the head constable experience, you write that on sight of it I have seen, I have also had a pinch of it, it had the bitterness and it had the thing, it gave me that, and by smelling that leaf, I could find out it gave irritation. That you record and thereafter do it. Only thing is, that is what I said. You justify and do it, record it, that is all. It is, see, in one case in Chennai, I would say that smack, brown color, it will be the smack. Huge quantity was seized. And later it was sent, he was detained, he was arrested, detained. And thereafter the forensic report said that it is Ajinomoto.
Yes.
Ultimately what to do?
Yes, yeah.
Later, if the report comes like that, what can we do? So, your belief, see that officer at that point of time, he found that it is he doubted that it is a smack. He seized, arrested, sent. Later it came as Ajinomoto. What can you do? So, you only thing is your satisfaction must be reflected in that document. You say that I am satisfied. I found out. I doubted. That is all. That you record and you send it.
Okay, thank you, sir. Thank you for your clarification. Thank you.
Yes. Anything else? Anybody? Students? Yes?
Sir, in your first slide, if I remember correctly, you said that the DNA evidence is a conclusive proof where you can forthwith convict an accused person. But doesn't it defeat the principles of natural justice, like the alteram partem?
No, DNA test, what do you want to know?
The DNA test, after DNA test, when we obtain the evidence, the DNA evidence, sir said that in your first slide, you said that...
Yes, it is 99.9%. It is confirmed DNA test is approved. Because the procedure itself is not so easy. Okay. DNA test, you collect the blood samples, not just like that. You have to go to the forensic department, get the card. That card has to be brought to the hospital. Thereafter, some blood samples has to be taken. And that card has to be packed properly, sealed properly, and thereafter sent. So DNA, that contamination, part of it, that is IO's mistake or the concerned officer. Otherwise, creating DNA and sending it to the hospital, it is not there. And thereafter, you have the DNA report where what is the percentage, it has been clearly given. And only one case I know, my experience, I know that Premananda case in Chennai, Madras, that is Premananda Big Sandar. In that case, Ram Jatmanani was the trial lawyer. He had brought in an expert, a DNA expert from England, and to demolish the prosecution case. But Supreme Court had negatived it.
And sir, are there any defense available to the accused, even if the DNA evidence is obtained?
I couldn't understand.
Are there any defense available to the accused, even if the...
No.
Not at all?
Not at all.
Okay, thank you, sir.
See, if you fail to give any sample, automatically adverse inference will come into you. And DNA, it's only, that it has been clarified, it's only taking a blood, so it is not that self-implications.
Good afternoon, sir.
Yes?
Anyone from the online participants who really wants to ask questions? Raise your questions.
So my question is,
may I please, Your Lordship, one question from Chandel Court.
Yes?
Your Lordship.
Yes?
The Joint Interrogation Cell, the JIC, isn't explicitly mentioned in the CRPC, nor in the new Act, but it's often used in serious cases, wherein in most of the time it is evident that a third degree is being used against the accused.
Yes.
If JIC isn't governed by specific laws, there's a risk of misuse. Ideally, interrogation procedures should follow established laws and guidelines like those in the CRPC and DK Basu judgment.
Yes.
Shouldn't JIC be regulated or brought under a specific legal framework to ensure accountability?
No, if they don't follow the procedure, third degree method are used, which we know. If that is the case, then that is the reason human rights violation, Human Rights Violation Act, Human Rights Court is there. You can file a complaint, you can send it to them. That is the remedy available for you, with you. When there is third degree method, illegal detention, violation of the Supreme Court judgments and everything, then the human rights violation, it falls under human rights violation. You can go to the human rights court. But only thing is, as I said to the prosecution, if you want to document it, I said wherever there is any lapse, you document it. Likewise, if you find out that there is human rights violation and there has been illegal detention or third degree method has been found, immediately make it as a memo. File it before the concerned court. Send it by email. You document it. See, tomorrow you cannot say that was there. You document everything. One thing is for sure, sir. Once a person, an accused person is taken to a prison after remand taken to the prison, the prison authorities are very cautious. They will not admit a person with third degree injuries or serious injuries. Or if again forced, they will record it in their prison register. That they will not hide it, because anything happens inside the prison, after that, he has been taken into the prison, anything happens, they are responsible. They will not take that responsibility. They will not tomorrow be blamed. They will not face the prosecution. For that reason, prison authorities are very clear in it. Either they will note the injuries found on it, on the person, or they will refuse. That is very clear. So if at all, if you find out anything is there, you make it, record it and send it to Human Rights Commission for inquiry or make a complaint, file a complaint.
Good afternoon, sir.
Yes.
This side. So my question is regarding the sanction for prosecution. I'm working in CBI.
Yes.
Recently, the Supreme Court has very much cleared that EV farm case, if you remember.
No, 17A sanction or 19 sanction?
218 clause 2 BNSS, which was earlier 197.
Yes, 197 sanction,
okay.
Yes.
So there is a one term mentioned there, in discharge of the official duty.
Yes.
I would like to know if there is any threshold which the Honorable High Court of Manipur is following to determine whether that act which are conducted done by mainly by the armed forces, which is very highlighted topic in the all extrajudicial killings allegations which has been there in Manipur. All these cases are halted just because of this term, whether the act which has done by the armed forces are under the during the discharge of the official duties. So I want to know if there is any judgment or any landmark cases or any threshold which has been decided by the High Court or Supreme Court to determine whether that act which should follow or whether that act falls under the act done in the discharge of official duties.
Yeah, discharge of official duties, there are empty number of judgments in Supreme Court, it has been said. See, only thing is that act of the concerned public police official should not be excessive. It should not be excessive. Again, you will ask what is excessive.
Yes, sir. That's my question.
That I will tell you. Whether it is excessive or not, you justify by your report. You justify by your report stating that I have asked his address, I have asked his details, he didn't agree for it, or he gave false information. When forcibly asked, he attempted to attack me. Thereafter, to safeguard that, we had to save ourselves. That you say that these are the persons who are present. If no private person is not there, you make another two constables or anybody who are accompanying you to say the same version, justify by that.
Okay, thank you, sir.
That is the way you have to justify.
Due to the
paucity
of times, so we will conclude the
districts you ask me.
Okay, district. So from the online participants, so if you have any more questions, so you may ask your questions.
Yes, I hope I have done justice to the topic. Anyhow, my senior is there, and he is going to be speaking about the charge and other things. And Mr. Chandru is there for BNSS and CRPC. But slightly, myself and senior will be on a different interpretation. No, looking at the facts of the case, not on the law. And I want to say a few words about the senior Mr. P.N. Prakash. I am here standing as an High Court judge, but for him, I would not have been there. My first CV was collected from Mr. P.N.P. when I appeared in his court. He asked me we know him in the practice also. Thereafter, senior became a High Court judge and he was a senior judge. And thereafter, on one of the hearing dates, he called me and asked me my CV. I gave it to him. And thereafter, it all started. Now I am a High Court judge. It was because of P.N.P. Prakash. I hope everybody gives a standing ovation to him. That is my request for him. That is what I request. I said we are indifferent because predominantly he was in the prosecution side. He was a leading prosecutor in the Rajiv Gandhi case. He was a prosecutor in NDPS case, DRI, Customs, CBI, and one of the excellent prosecutor. And I am here because of him. Thank you. Thank you very much.
From Chirigan district, they want.
Sorry, one question from one district.
From Chirigan.
Yes. What is the question?
Sir?
Yes. Yes. Yes, sir.
I would like to regarding the
yes.
In the case of Sundar, we have already made the sampling to the concept of Riva. Sample, outline, opinion. How the facility for PPT days. In such a case, our senior books to submit a prayer for PPT days. So
you ask him?
Excuse me, sir.
Sir, your voice is breaking, not audible. Make it short and.
It is possible research or
no, I'm still. we are not that clear. We'll do one thing. You have any other mic?
sir.
Yes, tell me, sir.
I'm investigating also sir. I would like to know one thing in the case of NDPS case. Where the Caesar.
Sir, can you drop your queries in the chat box so we can understand your questions? So you are not audible to us.
So we'll do one thing. No, one thing, officer. We'll do one thing. By the time you ask your technical person to find out, or also ask the technical person, after lunch, immediately you will be the first question and last question will answer that. Or my brothers will answer. After lunch. Because some technical error. Because for one question, I don't want to hold everybody.
Lossi is stunned.
He is unable to hear. You are unable to hear us, sir.
Sir, can you hear us?
You call your technical person there and inform him.
Sir. We can. Now we will close the Q&A sessions. So thank you so much.
You can come after lunch.
Sir, you may come after the lunch. Sir, I don't know, still staring at us.
Hello. Tavi. If you are audible, we'll do one thing. We'll break for lunch now, and after lunch we'll reconvene. And then, in the meantime, you can send your message in the chat box or in WhatsApp to any of the High Court staff. We will answer that. Thank you. Thank you. Thumbs up. Thumbs up. Thumbs up. Thank you, sir.
Thank you.
Thank you all. Thank you for the wonderful session, my lord. Thank you. Yes. We'll now break for lunch. I request the protocol to escort the dignitaries and the senior advocates to the dining place, to the venue of lunch. For others participants, lunch will be served outside the auditorium. We will reconvene here at exactly 2:30 for the next session, which is the technical session by Justice P.N. Prakash on the criminal trial management. Thank you.
हाँ
share lady stop
어 야예 따모
야예 디시
거기 이렇게 물로이 마기 스크린 같은
디비지 못하니
거의 뭐
stop 하면 야우되네
굴렸다 코인의 시야 떨어지고
ꯃꯌꯥꯝ ꯆꯠꯖꯔꯛꯑꯅꯤ ꯑꯗꯨꯝ ꯀꯦꯃꯦꯔꯥꯁꯦ ꯍꯧ ꯑꯗꯨꯗ ꯍꯥꯏꯈ꯭ꯔꯒꯦꯀꯣ ꯍꯥꯏꯈ꯭ꯔꯣ
All the participants who are attending through online and through physical mode, please come to the auditorium hall and to your respective places. Yeah, yes. 2:30, sir, we are supposed to reconvene, but it's almost past. Yeah, 5 minutes past. Yeah, yes, I hope. Yeah, yes, definitely.
ꯑꯗꯨ ꯈꯪꯗ꯭ꯔꯦ ꯌꯥꯝ ꯑꯩꯈꯣꯏꯅ ꯀꯃꯥꯏꯅ ꯇꯧꯔꯒ ꯒ꯭ꯌꯥꯟ ꯇꯥꯗꯦ ꯃꯥꯅ ꯍꯥꯏ ꯄꯣꯠꯁꯛꯁꯦ ꯃꯥꯗꯤ
ꯐꯖꯅ ꯍꯥꯏꯔꯝꯕꯅꯤꯅ
ꯍꯥꯏꯗꯤ ꯍꯥꯏꯔꯝꯕꯅꯤ
ꯃꯣꯏꯒꯤ ꯖꯁꯇꯤꯁ ꯀꯗꯥꯏꯗ ꯆꯥꯒꯦ ꯑꯗꯨ ꯅꯪ ꯂꯣꯁꯀꯤ
ꯁꯦꯁꯟꯒꯤꯗ ꯀꯣꯏꯁꯟ ꯑꯃ ꯖꯤꯕꯥꯝꯒꯤ ꯍꯪꯉꯛꯄꯗꯣ ꯑꯗꯨꯗꯣ ꯇꯦꯛ ꯑꯞ ꯇꯧꯒꯗ꯭ꯔꯥ ꯁꯥꯔ ꯍꯥꯏꯇꯥꯔꯦ ꯑꯩꯅ ꯁꯦꯀꯦꯟ ꯇꯦꯛꯅꯤꯀꯦꯜ ꯁꯦꯁꯟꯒꯤ ꯔꯤꯁꯣꯔꯁ ꯄꯔꯁꯟ ꯍꯪꯕ ꯀꯥꯟꯗ ꯇꯧꯔꯔꯣꯏ ꯃꯥꯅ ꯂꯥꯛꯇ꯭ꯔꯕꯅꯤꯅ ꯍꯥꯏꯗ ꯃꯥ ꯐꯥꯔꯁ ꯁꯦꯁꯟꯒꯤ ꯔꯤꯁꯣꯔꯁ ꯄꯔꯁꯟꯗꯣ ꯂꯥꯛꯄꯤꯗꯣꯏꯔꯥ
Before we start the second technical sessions, so we will take up the questions which was asked by the participants from the Hijam District Court. The question is, Lordship, it's to you. In the case of NDPS, sampling of seized articles had already been done at JMFC, Hijam, and also sent the original sample to FSL Pangai for expert opinion. However, there is no facility for purity tests. Hence, our senior officer advised us to submit a prayer to the concerned court of NDPS for resampling and sending the seized exhibit for purity test by the competent FSL where all facilities are available. I would like to know whether resampling can be done or not. From the Hijam districts? Yes, sir.
Good afternoon. Well, I'll answer this question which has been posed, whether a resampling could be done under the NDPS Act. Please understand, my dear friends, that sampling, resampling, all these are procedural in nature. Procedure in nature to arrive at justice. To arrive at justice, it is procedural in nature. So what is the normal rule? Procedure is the handmaid of justice. You are aware about that principle? Procedure is a handmaid of justice. It is not the master of justice. It is a servant of justice. So in a given case, because we really do not know what the police catch. The police will catch, as my friend, Justice Nirmal Kumar pointed out, they catch hold of surf powder, Sabina powder. I don't know whether surf powder, Sabina powder are available in Manipur, but in our area, something like that is available, and they will say it as one of the psychotropic substance, arrest the accused. So in such cases, where the rights of the accused goes into the fundamental aspect, whether the seizure itself is a contraband, then the special court under the NDPS Act has the power to take samples, send it, because at the end of the day, Article 21, which is a safeguard for the accused against false accusation. So don't worry about this. Boldly take a decision to send it for resampling. All right?
Thank you, Lordship. So are you clear about it?
No, they didn't ask. Someone somewhere.
Yes, I am clear, sir.
Okay. Thank you. So now we resume the proceedings for the second technical session. For the second technical session, it's my honor to introduce Honorable Mr. Justice P.N. Prakash, former judge of the Madras High Court. His Lordship obtained his BL degree from Madras Law College and was enrolled as an advocate on 18th January 1984 with the Bar Council of Tamil Nadu. Over the course of his illustrious career, His Lordship has held several significant positions. He was appointed as Additional Special Public Prosecutor by the central government in 1994 and was designated as Special Counsel by the government of Tamil Nadu to represent the city police before the Justice Raman Commission of Inquiry. His Lordship has also made valuable contributions to legal education, serving as a faculty member at the Tamil Nadu State Judicial Academy and the Sardar Vallabhbhai Patel National Police Academy, among others. Lordship was sworn in as a permanent judge of the Madras High Court on 14 April 2015. Today, His Lordship will deliver a lecture on trial management regarding framing of charges and handling of absconding accused persons. Now may I humbly invite Honorable Lordship, Mr. Justice P.N. Prakash, former Judge, Madras High Court, to share his erudite insights on trial management. Thank you, Lordship.
Hello. What dear?
That PowerPoint we have to.
Wait. When I tell you, you do that for me. Good afternoon, participants. It's very, very difficult to start a immediate post-lunch session and to keep the audience in thrall or attentiveness, because both the speaker and the hearer will be stomach full and will doze off. So how much ever best I will try to keep you in attention. When Justice Kotiswar Singh asked me whether I would come to Manipur, without batting an eyelid, I said, I want to come to Manipur. I want to come to Manipur and meet the people. After coming here, I find you people are so enthusiastic to know about things, and I find that there are other district judges in various courts who are joining online. Please understand, my South Indian accent in English will be little different from your Manipuri accent. So forgive me for that accent, and I will address you very slowly, not in the usual Madrasi style of speaking like a TV 9 p.m. anchor. I'm not a television 9 p.m. anchor to speak like that. My dear friends, before going to the topic, I just want to discuss with you certain fundamental things of criminal law. Justice Kotiswar Singh and myself, when Justice Kotiswar Singh was a judge of the Manipur High Court, and myself and about 6 judges from other high courts, we were selected to go to the United States to study the terrorism cases in the United States, come back and bring the good practices from what we have learned to India. So we all went there and we visited various courts, held a lot of discussions with the judges of United States. I learned one thing in the United States. What I learned was, United States has a population of 340 million, which is 34 crores. 100 lakhs is 1 crore, 34 crores or 340 million, right? I was surprised to know that 5 to 6% of Americans go to jail. It was a shocking response to me when I heard the percentage of Americans filling up the jails in America. So I wanted to test what will be the position in India. I came to my state of Tamil Nadu and conducted a research. In my state of Tamil Nadu, the population is 8 crores. 8 crores means 80 millions. 8 crores is 80 millions. There are 10 central prisons in Tamil Nadu. Central prisons means huge prisons in Tamil Nadu. There are 15 district prisons in Tamil Nadu. And there are 28 sub-jails in Tamil Nadu. 10 central prisons, 15 district prisons and 28 sub-jails in Tamil Nadu, which has a population of 8 crores. So I asked the IG of prisons, sir, on a particular day at 10 o'clock, if you are to take the head count of all the prisoners in all these prisons in Tamil Nadu, women, men, preventive detention prisoners, remand prisoners, convict prisoners, completely take head count of it, what would be the total number of persons, including persons who are arrested for preventive, everyone. Can you hazard a guess? Can anyone in this little audience, against an 8 crore population, on a particular day, how many people are likely to be in the jails in Tamil Nadu? Just don't be, see, I want you to be active after lunch. I want you to be participative. Children there, just come up with some solution. Come up with, don't never consult ChatGPT, don't consult Google. Be truthful enough, even if your answer is wrong, doesn't matter. Just hazard a guess. 50,000, excellent. Is district judge? Now this gentleman says 50,000. How many of you all are refuting him and saying no, it could be something more or something less? Yes. Or you are agreeing to what he says. 50,000 against a population of 8 crores. Yes. Ladies, are you not understanding what I am saying? 50,000, because he will not punish you, no, like, is he going to write your CR? Manipuri women must be very bold. I don't want them to be scared. What about the police officers sitting there? Yes, police officers. Aha, that is police. That is police. Bhaiya, aap army hai kya? You are army? CRPF. कोई police officers नहीं है क्या यहाँ? Police officers are not here in this audience. Police officers are there? Online. Can anyone, because they by now they would have consulted Google. Because at least here I am having a high contact with you all to find out. What about children? Why don't you hazard a guess? No, you are looking at Google. No, don't. Be fair. Be truthful to yourself. Be truthful. I am not going to punish you if the answer is wrong. So the army man, the CRPF paramilitary says 1 lakh, judicial officers say 50,000. What about the students? Against a population of 8 crores, 80 million. Come, backside. Why students? You are dead silent. You are scared. No. By now you have consulted the. I'll tell you, the population, the number will be 25,000 maximum. 25,000 maximum. Supposing if there is going to be a BJP agitation, Congress agitation, where Congress people are arrested and there is Congress party volunteers, BJP party volunteers, DMK, if they are arrested and put in thing, they will hardly add to 2,000 to 5,000. So maximum 30,000 people will be in jail. After retirement, I started working in the prisons for the development, I wanted to do something for the prisoners. What I found was 80% of the prisoners are from the marginalized section of society. They are people from the very, very poor background of Indian society. Most of them, I calculated, were ordinary pickpockets, people who would have stolen a cell phone, and these are all the people who throng our jails. I tell you, my dear friends, this is the position not only in Tamil Nadu, this is the position in Uttar Pradesh, Bihar, Manipur, Northeast, throughout India. So, 25,000 against a population of 8 crores is 0.0. Now you can use Google and tell me how much is 25,000 against a population of 8 crores. What is the percentage? I'm able to see you. Google, you're seriously talking to Gemini. So ask Gemini. What is Gemini saying? 0.0312, right? So this question I asked for myself, my dear friends, after having been a criminal lawyer for 30 years and a judge of the High Court for 10 years, I asked this question to myself, are we a criminal society? Are we a criminal society? Are Indians a criminal society? The answer I got was, Indians are not a criminal society. We Indians, whether anywhere in India, we are not a criminal society. Basically, we are not a criminal society. We are not a criminal society, not because our courts are very strong, not because our police is very strong, not because our paramilitary force is very strong. We are intrinsically good people. We are intrinsically good people, and that is exactly the reason, in spite of all these institutions, we are lawful. Go to your house, find out your ordinary cook, your housemaid, your driver. You hand over the keys to your housemaid and you go and leave. Is she stealing anything from your house? You would have left your purse in the car. How many times the driver would have come and given the purse to you and gone? Would you have taken 1 rupee from your purse? He comes from that section of the society where for him, for the paltry salary you pay, his honesty and truthfulness, not because he knows BNSS, BNS, IPC, CRPC. He doesn't know IPC, CRPC and all. He doesn't know about it. He doesn't know remand, judicial custody, all that nonsense only we know. He has only one sense of honesty in him. Then you may ask me, I asked a question to myself, how is it that we are able to maintain this amount of law and order in this country? There are 2 orders in law. One is social order and public order. Public order is enforced by state. You must have read the classic judgment of Justice Hidayatullah in Ram Manohar Lohia versus State of Bihar, 1966 Supreme Court. Dr. Ram Manohar Lohia versus State of Bihar. So Hidayatullah, Justice J would have stated, there are 3 circles, concentric circles. The big circle is law and order. What is law and order? Some 2 fellows fighting in the road, somebody picking a packet, somebody doing an isolated act of offense. This large circle is law and order. The second circle is public order. Public order is where the even tempo of the state is disturbed by that. Whereas when somebody is going to steal someone's purse, the public order is not disturbed. Law and order only is disturbed. So public order is something which disturbs the even tempo of the society. Then the third circle is the society, the protection of the state, security of the state. So security of the state means what? When terrorists are going to threaten the very security of India, very sovereignty of India, it's a very small one. Public law and order, public order, security of state. 3 concentric circles. This is on the right side. On the left side, you have social order. What is social order? Social order is the order which society itself maintains. Society itself creates so many institutions to maintain social order. In India, social order is very, very strong than public order. Your social order is, your family is a social order. Your caste is a social order. Your religion is a social order. Your way of worship is a social order. These are all social orders which are keeping India tight and peaceful. Only when the social order breaks, public order comes into effect. For example, I distinctly remember Hindus and Sikhs were living very, very peacefully in 1980s and all, in Delhi, everywhere. The social order between the Hindus and Sikhs were so fine, very well. If we used to feel, the Hindus used to feel that if there is one Sikh in a train compartment, you feel you are very assured that the Sikh is there to protect you. This is the amount of belief South Indians had. But one incident that took place, assassination of Mrs. Indira Gandhi by a Sikh, resulted in huge public order. For 10 years, the social order broke. What order broke? social order broke. When social order broke, public order became, state was not able to enforce public order for 10 years. As an Indian from South India, please mark my words, I did not say that I am a South Indian. I am an Indian from South India. I am not North Indian, Northeast Indian, West Indian, no. I am an Indian, like Dr. Ambedkar, whose fan I am, said in the assembly, Constituent Assembly, we want to be Indians first, Indians next, and Indians last. You must read his speech on 25th of November 1949, the grammar of anarchy. He will say, I don't want anyone to say, I am a Hindu first, an Indian next, Indian first, a Muslim next, all this. I want everyone to say, I am an Indian first, Indian next, Indian last. So I am an Indian from south of India. So when I was watching the Manipur events from south, from the papers, TV news channel, what immediately struck me was social order had broken in Manipur, and that had resulted in public order being disturbed. I am not here to tell you why the social order broke, what was the reason for the social order break, because I do not know. I do not know. Only Manipuris will know why the social order broke. I am not competent to speak about why the social order broke. But I, as an Indian from the corner of India, watching the events, felt that, my God, there was social order in that place. The social order broke, and that resulted in public order. Like the social order which broke when Mrs. Gandhi was assassinated. Social order broke when Mahatma Gandhiji was assassinated. So social order breaking resulting in public order. Now, why I am saying all this is, I want to drive home the point to this audience, a few fundamental aspects of crime in this country and how it has to be handled by us. There are different theories of crime. You have Lombroso's theory, H.L. Hart theory. So many jurists are there who speak about the crimes. I'll tell you, even before all these people could think of, there was one jurist in this country called Manu. In Manusmriti, he would say, Sarvo dandajito loko, durlabo hi suchihi naraha, dandasya hi bayat, sarvam jagat bhogaya kalpate. What he says is, Sarvo dandadito loko. Loko in Hindi is lok, people. Sarvo is survey. Sarvo dandajito loko. People fear punishment. Durlabo hi suchihi naraha. It is very, very rare to find a person who is inherently good. Fear of punishment only can deter a person from committing crime. Otherwise, given a best opportunity, the animal inside us will come out. Dandase hi bayat sarvam jagat bhogaya kalpate. So others are able to enjoy their properties because punishment, the king has to give the punishment for the offender quickly, expeditiously. This principle was echoed by Lord Macaulay when he drafted the Indian Penal Code. He said, it is not the enormity of sentence that can deter crimes, but by certainty of sentence. In NDPS Act, you kept 10 years imprisonment, that, this, death sentence, all that you have kept. Has NDPS crimes reduced? It has not reduced. When will it reduce? It will reduce only when certainty of punishment is there. So, as judicial officers, as lawyers, as police officers, enforcement of things, we must have to now work for a society to ensure that there is certainty of punishment. As long as we are not able to carry it forward, it will be very difficult for us to maintain law and order. Law and order maintenance will become very difficult. Now, this evening's topic which I am going to handle to you is charges and framing of charge. Justice Nirmal Kumar pointed out this morning the various process of trials. Excuse me. The various process of trials. Charges framing is a very, very, very important aspect of a criminal trial. Charges framing is like framing issues in a civil case. Charges framing is most important to determine how to proceed further. The Code of Criminal Procedure 1973 as well as the present BNSS provides the various sections for how to go about the framing of charges. I am not going to go into magisterial court framing charges. I am going to confine myself to sessions court framing charges. All right. My dear friend, I request you to put one BNSS 3 sections of BNSS in the screen. Ah, 248, 249, 250 of BNSS. You put that one by one, 248. You can download BNSS and show this position, no? I mean, I thought you would do that. Can somebody help him to? Anybody who is technically qualified? Oh God. So there is a communication gap. The communication gap was, I gave my friend one slip and asked him to, when I am addressing, I requested him to display section 248, 249 and 250. What he thought was, literally only that slip should be displayed, he thought. This is where, you know, communication gap comes. What I expected from him was, he will display that section for us to understand. That was the problem. Yes. See, as Justice Nirmal Kumar pointed out this morning, after the case is committed to the Court of Sessions, it starts off an important thing called framing of charge. First, what section 248 says is, in every trial before a court of session, the prosecution shall be conducted by a public prosecutor. So you will have in all your district courts a public prosecutor who will conduct the prosecutions. So in a sessions trial, the prima facie, the most important thing is that the prosecutor should conduct a trial, not a private person. A private person cannot conduct a trial in a sessions case, right? 249 is very important. When the accused appears or is brought before the court in pursuance of a commitment of the case under section 232 or under any other law for the time being in force, the prosecutor shall open his case by describing the charge brought against the accused and stating by what evidence he proposes to prove the guilt of the accused. My dear friends, the biggest problem in our country, in our old system, is that this 249 is not followed in any court in India, to the best of my knowledge. This 249 is such an important section which gives the public prosecutor the right to open the case, because what the police will do, police will complete the investigation, file the final report along with various 161 statements, this, that, everything. And in the charge sheet, the police will write, according to me, in my opinion, these accused have committed an offence under 120 capital B, Red 302 IPC, 326, 324, blah, 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 all that they will put, and they will file the final report and go. The session judge is not bound to go by what the police opinion is. That is the police officer's opinion after collecting evidence. The session judge is required to ask the public prosecutor, Mr. Prosecutor, open up your case and you tell me how you are going to prove, what is the nature of evidence you have to prove against the persons who are standing in trial. Now, the most saddest part of it is that our public prosecutors are not in the habit of reading the case diary at all. They don't read the case diary at all. They will have one Sinha as eyewitness and another Sinha as Panchanama witness. They will put the Panchanama witness Sinha and ask him about eyewitness in the 161 statement. That Panchanama Sinha will not even know about what the eyewitness is. He will be speaking about seizure. This fellow will turn hostile, thinking that he has been won over by the other side. In fact, that fellow's evidence will be for Panchanama. This Sinha will be for the eyewitness. This is comedy is happening throughout our country. Somewhere this comedy has to be stopped. There must be some seriousness in sessions trials. When you ask the public prosecutor to start the case and read and tell the court how he proposes to prove the offence, first thing is that fellow will read the papers. Then he will get a fair idea as how he is going to prove it. Now, another problem we face in our country is police have the thing. In India, one thing can be very sure. A police constable can spoil the career of anyone. One police constable is enough to spoil the career of anyone. One 161 statement, include him as an accused, finished. His entire life will go. So, what happens is, in group clashes, in villages, group clashes, one particular community group will attack another community. What this fellow will do is, he will put all the youth with the aid of 149 IPC. With the aid of 149 IPC, he will include about 10 youths of that community. And those poor fellows will have to come and standing in trial. Until the trial is over, he will not get public employment, because FIR pending, no public employment. By the time the trial is over, he would have crossed the age of 25 to get public employment. We have seen this even in judicial officers' appointments. 2 or 3 judicial officers have cleared the examination, just they were included with 149 thing in a charge sheet. Finished. We cannot do anything. So, what you people have got a responsibility to ensure that when you ask the public prosecutor to open the case under section 249, now at present what happens? A1 will file on discharge application, then counter. For 100 hearings, it will go on counter. Then on fine hearing, you will dismiss the discharge application of A1, then A2 will file a fresh discharge application. Like that, the trial will go on for 10 years, only on charge framing, which is not at all contemplated under the code. It is not contemplated. What does the court say? Court says, Mr. Prosecutor, start your case. Tell me how you are going to prove it. Then the moment he starts a case. You hear, then you decide that, all right, out of 8 accused, A7, no. Even if this evidence is completely translated into as a legal evidence, that fellow cannot be convicted. Discharge him. Discharge him then and there. Have the spine to do it. Because when you do that, first of all, police will get a message that you are a no-nonsense judge. Next is, the common litigant will have faith in the judicial system. He will have faith that a false case, if it is to be put, here is a judge who could even discharge me at the stage of framing charge. Read the next line. Discharge. The accused may prefer, see what had happened was, in the earlier CRPC, this provision was not there. This 251 was not there in CRPC. So, they were all filing these discharge applications one after the other. To get over that, BNSS says within 60 days it should be. But the problem with BNSS is, it doesn't say what is the default. It doesn't say that in default, you shall proceed with the framing of charge. This is a big lacuna which High Courts and Supreme Courts will have to handle when it comes. Had BNSS left it like that, then we could have made the judiciary to hear the charge framing as a regular feature. Now, 251 says that file application. Now, read subsection 2. If upon consideration of the record of the case and the documents submitted therewith, and after hearing the submissions of the accused and the prosecutor's behalf, the judge considers that there is not sufficient ground. Please understand, there is not sufficient ground for proceeding against the accused. He shall discharge the accused and record his reasons for so doing. What you are required to do is, I heard this so and so and so. I find that the allegations against A7 is the statement of so and so. His statement says that he had not seen it, but he had heard someone saying it. Therefore, this itself is not enough to, even if this man is going to come and verbatim repeat it in the court, it will not be sufficient to convict the A7. So, I am discharging A7. Write a reason. If your reason is not good, there is a superior court, High Court in division can reverse it or do whatever it is. Don't worry about it. Don't be worrying that what will happen in High Court. Don't worry about it. You act as per your conscience. Yesterday was a very happy day for me when I read that one Rajendra Singh, a session judge in Delhi, discharged Arvind Kejriwal, this fellow, all the fellows were discharged. He has written a 528-page order. I had just had to completely read it. What I found was, doesn't matter. Doesn't matter if it is going to be a high-profile case. This, he says that it's a public policy, it's a liquor policy taken by the cabinet. Where is the corruption in this? He has written. We do not know whether it is could be reversed by the superior court or we do not know. But what I appreciate is, I appreciate the fact that there is one session judge who is able to say, boss, there is nothing in this. Then I had always had admiration for that Saini. There was a judge in Delhi. He said 2G case, nothing. There is not a scrap of papers before me to convict. He said, I kept the doors open for the CBI to produce evidence. My door was kept open for so many days, they didn't produce evidence, he acquitted them. It was a high profile case in Tamil Nadu, implicating some of the ministers of Tamil Nadu, etc., etc. It's a different issue. We are not politicians. We can't take political stands anywhere. We are pure professionals, lawyers, we are prosecutors, we are judges. So you do your duty by understanding the law and taking a decision. Wash your hands off like Pontius Pilate, who says, yes, I wash my hands off. It is for the Caesar to confirm the death sentence or not. That's all. So you don't have to keep worrying about what will happen, etc. But I know your problem. Next minute, your High Court, you get a dig from your High Court saying, why did you discharge? You took money and discharge. All these things will come. I know the travails of a judicial officer. I know. Next minute, one anonymous petition will go. The judge took 10 lakhs to release A7. And you will have to face the music. This is what? But understand now, you have very, very proactive, reasonable Chief Justice like Justice Sundar here, who will not resort to such things, who will be very balanced in his approach, who would find out the correctness of a judicial order before taking administrative actions. Once we are protected by our High Court, we can go long extent. So, now that as long as Justice Sundar is here, you can be rest assured that you can boldly be an active judge. All right. You be an active judge, don't be an activist judge. There's a lot of difference between being an active judge and an activist judge. You are not an activist. We are not activists. We are not activists. We are active people. That's all. Right? So, this is the fundamentals of framing charge. I think I got only 5 more minutes. See, I want to take you to a model charge in Rajiv Gandhi assassination case. I do not know how many of you all are aware that there was a Prime Minister in India called Rajiv Gandhi. I mean, I can't presume in life. Supposed to, he was 1989, elections were declared. And he was likely to, the Congress was likely to, 1992, I'm sorry, not 1989, 1992. Oh, 1992, Babri Masjid. 91. 92 is Babri Masjid, no? 91 is general elections. So he comes to Tamil Nadu for campaigning. At Sri Perambatoor, a bomber ticks off the bomb and he is assassinated, along with 17 police officers die. This is the long and short of the case. The question was, when Rajiv Gandhi was the Prime Minister in the earlier time, he had sent IPKF. There was a problem in Sri Lanka. Northern Sri Lankans were asking for a separate Tamil land, and there was insurgency going on in that country. And in order to settle this, there was an accord, Indo-Sri Lanka Accord was entered, by which we sent Indian peacekeeping force to Sri Lanka to maintain the thing. There are a lot of allegations, let's not go into all that. The sum and substance was, the LTTE's chief, Prabhakaran, entertained the thought that in this election, if Rajiv Gandhi were to come, he will not be supportive of our struggle for a separate Tamil homeland. So we assassinate him. This is the story. Now I'll take you to the charges. Put the charge. And I gave you one we remove that. No, I gave one pen drive, no?
Yeah, sir, it's in it.
Take it.
Stop the robot.
So, the long and short of the story is that the LTT was a dreaded organization. They were able to carry out assassination of their own Prime Minister, President Premadasa. They were able to liquidate their rivals. The LTT were not the only Tamil organization that were fighting. There was the TULF, there was PLOT, insurgency groups. In all insurgency groups, there will be different factions of insurgency. So they were eliminating one after the other their rival groups. That is, they were eliminating the Tamil groups with a rival to them. So one such group was eliminated in Chennai. They came, eliminated, and they went. That emboldened them that they could operate in Tamil Nadu, and they planned it. Now, I'll take you to the first charge. How do you do it? Yes. take time to read. That you, A1 Nalini, A2 so and so and so, all these are Tamil names. You will find it very difficult to comprehend them. Does not matter. Come over to 26. 26 is Guneshwaran. After that, with Prabhakaran absconding, sir, I will give you this thing and go. You don't have to take photos. I'll give you. I'll share it with and go. Huh? No, I give it to you. Don't worry. Now, see, Sivaras says here, Prabhakaran absconding, Pottu Amman absconding. Pottu Amman was the intelligence chief of Prabhakaran. Akila absconding, Bakinathan absconding, Shivarasan since deceased. Shivarasan was the person who masterminded the whole thing, and he is killed by our forces in Karnataka. Our special investigation team zoom in on him, and there is a battle, fight, he is eliminated there. And Danu, since deceased. Danu is a lady who had the belt bomb in her thing, who detonated, and she died. So these are all the absconding and deceased person. Why I am telling you is, when you frame a charge of conspiracy, you are not necessary to frame charges only as against the living persons. You could also mention the names of those persons with whom the conspiracy was entered into. Mentioning of the names of those persons with whom the conspiracy was entered into is essential. Mentioning of names is not indictment. Please understand. Mentioning of names is not indictment. Mentioning of names is not conviction. Mentioning of names is to make sure that, see, for example, myself and he conspire to eliminate him. If we take it, we finish the job. So it's a conspiracy to eliminate him. But somewhere he dies. He doesn't face trial. He dies of heart attack. He does something. There cannot be a one-man conspiracy. Conspiracy requires minimum 2 persons. So I am alive, he is dead. So we both entered into a criminal conspiracy to wit, eliminate him. So when you frame a charge for conspiracy, it is essential that, because understand, my dear friends, conspiracy is an inchoate offense. It is an inchoate offense. It's an offense for which the very mens rea is your bad intention. It is not like other offenses where there is a physical manifestation. If 2 persons, if both of us have the common intention to eliminate him, just because police are able to thwart our attempt, so a crime has got what? Motive, intention, preparation, attempt, commission. Is it not? You have a motive to do it, then the motive develops into an intention, the intention goes into preparation, preparation goes into attempt, attempt goes into commission. So at the stage of attempt itself, he is protected, he is saved. We can be both charged for conspiracy under section 302 IPC because we both had the criminal intention to assassinate him. That is conspiracy. It doesn't matter whether the assassination was successful or not. So conspiracy is a substantive offense after 1909. Originally, it was a species of abetment under section 107 IPC. 1905 onwards, what happened was the freedom movement shifted from violence, Aurobindo Ghosh, these were all the people who were into militant violent thing. So conspiracy was included into the IPC to make it the very thought itself is a thing. So conspiracy is a substantive offense. You will have to say who are all the conspirators, and if you now read carefully, Dixon, Kishore, so and so, it's deceased. and between July 1987 and May 1992. So in a conspiracy, what is required is period is required. It is not necessary that you have to fix the correct time and date. Please understand, conspiracy is hatched in secrecy and executed in darkness. 1955 Supreme Court. Conspiracy is hatched in secrecy and executed in darkness. So you want, only the state police have got the stupid idea of, I went with team of officers at Manipur railway station, I saw all the accused conspiring to burst the Manipur, I rounded him up and I caught him. I can never known 10 accused standing in Manipur railway station and wanting to set fire to Manipur. So that is not conspiracy. Conspiracy is hatched in secrecy. That is why section 10 of the Evidence Act is very important in conspiracy trials. I am not going to touch upon trial. I am going to touch upon only on charges framing. Some other session we can think about trials. So when you frame a charge, place, time is necessary. Next, at Jaffna, Mattakkal, Velveti Thurai and other places in Sri Lanka, Rameshwaram, Kodaikanal, Kodikarai, Madras, Sriperumbudur and other places in Tamil Nadu, Bangalore and other places in Karnataka, Jaipur, Delhi and other places, because this conspiracy was not, it had a very wide range. So every conspirator, it's not necessary that every conspirator should know the evil design. No. It is enough that he participates in, it is that hub theory, hub. K.T. Thomas, Ajay Agarwal judgment, if you read, hub theory. So a cycle tire, tube, hubs, no? So like that one hub, ultimately the tire has to run. So hub theory. So this is how it is. Next page, how do you change it? Ah, yes. Entered into criminal conspiracy to do or cause to do illegal acts to wit. Now, my dear friends, you must know the difference between illegal act and offense. Every offense is an illegal act, but every illegal act is not an offense. This is fundamental criminal law. Every illegal act is not an offense. Every offense is an illegal act. An offense is defined in section 40 IPC. For example, if a landlord doesn't, if a tenant does not give landlord rent, it could be an illegal act under the Rent Control Act of Manipur. Manipur Rent Control Act may say that tenants have to pay the landlord the rent. Non-payment of rent is not punishable under the Rent Control Act. Non-payment of rent would entail eviction of tenant, that's all. It will lead to civil consequences, not criminal consequences. So there are several whereas conspiracy to do illegal acts is an offense. Conspiracy to do an offense, it's not a thing, is an illegal act itself is an offense. If you read the section, you will understand. So you will have to be very careful in framing. And to infiltrate in India clandestinely. So when you infiltrate into India clandestinely, you are breaking the immigration laws of India. One can come to India only with a passport and a valid visa. If you are going to come to India through illegal process, you are violating those laws. So that is also a part of the conspiracy. Conspiracy to murder is one thing. To effectuate the murder, you are conspiring to do so many small acts. What are the small acts? Infiltrating into India, buying wireless sets, putting up wireless sets in a place, because wireless set is keeping it again Telegraph Act, Foreigners Act violation, because you are not an Indian, you are Sri Lankan, coming to India through illegal channel, you are violating Foreigners Act. So the charge must include all this. Bringing bombs. Bombs will come under the Explosives Act, Explosive Substances Act. So that is included. One after the other, you must have to put everything. To assassinate Rajiv Gandhi, former Prime Minister of India, who were likely to be with him, and others who were likely to be with him. Please understand, my dear friends, every man is presumed to know the consequences of his act. If I am going to throw a bomb there, the consequences of it, several people will die, several people get injured. So I am liable for the death as well as injury caused to others. I am 304th. So I am liable for the probable consequences of my act. So you keep a big RDX in you, detonate the RDX on Rajiv Gandhi, and you caused not only the death of Rajiv Gandhi, you intended the probable causes of the security people around Rajiv Gandhi. And they did die. And several people were injured. About 10 to 15 people suffered grievous injuries, burn injuries, everything they suffered. So separate 326 was attracted. The down you will see, just the previous page. You will find one character here, Hari Babu. I have kept the pointer there, Hari Babu. Have you got it? Oh, they are not visible here. Where is it? Where is the pointer? No. Put it back. Here. There is a point. Yes, Hari Babu. Hari Babu since deceased. It is Prabhakaran's modus operandi to take photographs of all the assassinations he does. So he will send a photographer to cover the assassination. So Hari Babu was sent to cover the assassination, but the mistake Hari Babu did was he went too close to Rajiv Gandhi. So in that blast, he also died, but the camera was caught. The camera only gave us the real lead to the persons who were, the camera was taken, washed, and the photographs showed the assassin and then the others. So why I am telling you is, Hari Babu is also part of the conspiracy, because he knew that he has to take the film of the assassination, though he was not the assassin himself. In all conspiracy cases, you must have to invoke 34 common intention. There is a common intention. I hope you know the distinction between common object and common intention. Common object is an offense by itself under 149. Common intention is a rule of evidence in IPC. It is not an offense by itself. It is a rule of evidence, right? So this is most important. Then after the conspiracy, their job did not end after assassinating Rajiv Gandhi. They have to escape to Sri Lanka. So they had taken houses that you will say that after, and likely to be with them to cause disappearance of evidence thereof and escape, to screen themselves from being apprehended, to harbor the accused and escape from the clutches of law, and to do such other acts as may be necessary to carry out the objects of the criminal conspiracy as per the needs of the situation, and in pursuit of said criminal conspiracy and in furtherance of the same, you A1 886, so and so, so and so and so. The last, the charging section. You are liable for these offences. 120B read with 302. Many of you all are framing charges under 302 read with 120B. Totally wrong. 120B should come first. Conspiracy to charge, to commit murder, read with 326. What is 326? About 5 people suffered injuries. 324, 5 people suffered ordinary injuries. Right. 201, screening evidence. 212, harboring. 216, 3, 4 and 5 Explosives Act. 25 of the Arms Act. Section 12 of the Passports Act. Passports Act, they were entered India without passports. Section 14 of the Foreigners Act. Section 620 of the Wireless Telegraphy Act. And 3, 4 and 5 of the TADA Act. So your TADA Act is now the Unlawful Activities Prevention Act. If you understand this one particular case framing charge, you will be able to frame charges in all your silly, simple cases which the police bring. Nothing. There will be nothing for you. That's why I brought the most complicated charges frame for you to understand the entire gamut of charge framing. So all these people are charged for the substantive offense of conspiracy, read with these offences, and the next is Nalini. Secondly, that you, Nalini, did so and so, so and so, so and so and so and so, and thereby Nalini committed an offence punishable under section 302 read with 34 APC. So the charge against Nalini was Nalini had taken the assassin and helped her to go near Rajiv Gandhi. She stood a little away from Rajiv thing for the assassination to happen. So her presence was proved in the camera of Haribabu. The photo of Haribabu showed the thing. So she was brought under 302 with 34 common intention. If the belt bomber or if the real assassin had been alive, it would have been 302 simpliciter. I hope you understand. Is it very confusing? 302 simpliciter. When you are doing it with a common intention, 302 read to 34. I think I'll stop with this. No, the other charges will go on like that. Right? Third charge against Nalini. Like that, you must frame individual charges against all the accused. Suppose there are 10 accused, after the single conspiracy charge, you must frame individual charges against the individual acts, against A1. You are all, what you are doing is you are clubbing and framing charges. That is probably because you are not taking the pains to frame charges, you are asking your bench clerk to frame charges. That's a problem. Henceforth, stop asking your bench clerks to frame charges, stop asking your stenographers to write judgments. All this have to be stopped, the system. It's better that you people start working yourself. Then you, because what a poor bench clerk, that fellow will copy paste the charge sheet and make it into charges. That will happen. On the contrary, if you are going to make the public prosecutor argue on charges, then the charges will be very beautifully framed. It will withstand judicial scrutiny. It will be easier for you to appreciate the trial. See, my dear friends, all these positions were there, were working very well as long as we had jury trial in India. Till 1955, we had jury trial in India and assessor trial. Jury trials used to be in the presidency towns of Madras, Calcutta and Bombay. Assessor trials used to be in the Mofussil's area. After the infamous or famous Nanavati case, we gave up jury trial and it became a judge trial. When it became a judge trial, till at least till about 90 or till about 90s, yeah, the session judge used to fix the diary on a Monday, and by Friday you will have 313, forthcoming Monday arguments, Wednesday, Thursday judgment. This used to be the calendar fixed for sessions cases when we were in thing. But today, the best criminal lawyer today is the lawyer who is able to prolong the cases till the witnesses die or turn the witnesses hostile. Thank you. Any question from those participants? Because after that there is going to be a brainstorming session by Chandru. I have really eaten into Chandru's time. Yes? So, no questions. Thank you.
Thank you, Lordship, for sharing and enlightening us the various narrations of the new criminal laws regarding the framing of charges. And Lordship has mentioned the most significant part of the especially criminal law, the Rajabihari. Thank you. And I regret to inform you all that there is a slide in the program schedule. We will proceed to the third technical session, and the tea break we will have after the board of thanks. So now we will commence the third and concluding technical session. For the last technical session, I am humbly honored to have with us the respected Shri E. Chandrasekaran, advocate and special public prosecutor for the NI at the Madras High Court. Sir is widely acknowledged as a leading authority in criminal law and legislative developments. Notably, he led the National Learning Workshop on the 3 new criminal laws organized by the Institute of Legislative Drafting and Research under the Legislative Department, Ministry of Law and Justice on 24th April 2024. In the final technical session, Sir will address the gathering on the topic, new criminal laws and their application in trials and appeals. May I have on the stage, sir? Thank you.
Good afternoon, everybody. Are you all happy? Yes. Is it audible? Is it audible? Yes. My lords, the Honorable Chief Justice of Manipur, my lords, Honorable Justice Nirmal Kumar from Madras High Court, and my lords, Honorable Justice P.N. Prakash. You can understand the difficulty of an advocate to argue before one High Court judge. This is a special bench. My lords, Honorable Justices of Manipur, I am not conversant with the name, my lords. I beg your pardon. Yes, my lords. So now it is 5 judges bench, constitutional bench. So the work of a council will be very difficult. One lighthouse from Madras has moved from Chennai to Manipur. So what is loss for my state is gain for our state. Right? As my lords, Honorable Justice P.N. Prakash has said, God has given you a very fantastic human being in the first place, a great teacher. Because from the morning, none has introduced him as a great teacher. He is an envious teacher. I envy him because I was imagining that he is a master only in commercial laws, arbitration laws, and he has proved that that is wrong when he sat on the criminal side. You should read one judgment, Muhammad Abbas versus Union of India. I envied the judgment. I told in National Judicial Academy that it is a doctoral judgment. If you have a chance of reading that, do that. Then thirdly, National Judicial Academy people told me that he handled a class in artificial intelligence. What is the subject? AI. 2 people were invited from Chennai. One is the head of the Department of Artificial Intelligence from IIT Chennai. And my lords was the panelist, but he as usual has eaten that man, and that man has paled into significance. So such a terrific teacher is available in Manipur. So please, yes, please get drenched in that rain, torrential rain of wisdom. And second is, from the morning, the job of a speaker, if he is especially the last one, is very difficult. My lords, Honorable Justice Nirmal Kumar, a very good human being. Anybody can go to his court. Fine gentleman, he don't have the silent revolvers to fire. You can also come and practice in Madras High Court before him. Very humanist, and whenever you stumble upon some facts, he will ask you to wait for some time. He thoroughly goes through the bundle and gives you the relief. So my sincere pranams to Honorable Justice Nirmal Kumar also. And coming to my Lord's Honorable Justice P.N. Prakash, I have become a speaker on law. I am a toddler on law, that I am aware. Without reading the judgments of Honorable Justice P.N. Prakash and Honorable Justice Nagamuthu, I swear here that I am a zero in that. We all read the judgments and we are all just performing the act of priest in a temple. Vedas were revealed by gods, and like priests, having read that, they are all making some, I can also confess, drama here, right? Having said so, with the blessings of my parents and my teacher, Mrs. Vrinda Mohan, who is also my senior in profession, I am in front of you. And this is a democratic class. If you feel that it is boring, please raise the hands. I will stop. Okay? But not now. I will just come down with you. Yes. Yes. You want me to be here or here? Yes. Yes, I understand. Whenever you go astray, judges will put us right in the right path. That is the reason I said it will be very difficult when 5 judges are there. Yes. The topic assigned to me is new criminal laws, application of that in trial and appeal, right? To cut the long topic. Any explosion, brother? No. To cut the long story, long topic short. To cut the long topic short, I will say that I am going to dwell upon the application of new criminal laws in trial. As a lawyer, I am going to say that appeal is an extension of trial. So, the tail portion of the topic I am not going to deal now. We will just see that the new criminal law BNSS has got certain reforms in that, right? What are they? Firstly, to understand any law, we will come to the aims and objective, objects and reason. Point 1 is the name of the act was changed by the Parliament. Now it is called as the Bharatiya Nagarik Suraksha Sanhita. That is India, that is Bharat as stated in the Constitution, the name was changed, and Nagarik is citizens, Suraksha Sanhita is protection code. The intention of the Parliament is, the parliamentarians thought that certain aspects of arrest, investigation, inquiry and trial has to be regularized in a straight-jacket formula of making time as the essence of each act. So, every stakeholder under the BNSS should work under certain time scale, and almost in new BNSS, every stakeholder was assigned a time specific role. The word used is also shall. Whenever the word used in law is shall, what does it mean? Is it mandatory, or when the word shall is used in law? Mandatory. When may is used? Directory. As an advocate, no, I can say that every shall is not shall, every may is not may. Right? I have reasons to say. In CPC, 1999 an amendment of CPC came, 2002 amendments came, and we people from Tamil Nadu, when I was a raw junior, I became an advocate during 1997, and whenever strikes were there, I feel very happy. I am not an exception, no? You feel happy whenever there is a strike? No, your judges cannot see you. You are sitting in the behind, no, you can say. Yes. What has happened is, Salem Advocate Bar Association versus Union of India, they agitated the amendments before the Honorable Supreme Court. Especially They challenge the provisions of section 148 of CPC. What is 148 of CPC? Return statement has to be filed. No civil lawyer here. Yes, within 30 days. The word used is shall. However, the Supreme Court said there is no consequences on default of non-filing within 30 days. So the Supreme Court has held that if the word shall is there, bereft or divorce of a consequence to that, then every shall is not shall. So Supreme Court in the case of Salem Advocates Bar Association versus Union of India 2005 has held that that shall is not shall. So it is may. Right? This is one thing. Now I am taking your attention to, because why I am telling all this at the outset is, in many places in BNSS the word shall is used for time frame. Then coming to Lalita Kumari versus Government of UP 2013 Constitutional Bench. What is the significance of that judgment, my dear students? Lalita Kumari versus Government of UP 2013 Constitutional Bench. Section 154 CRPC regarding registration of FIR. Is it mandatory or directory? No idea? This Lalita Kumari is a very famous landmark case regarding section 154 subsection 1 of CRPC, where the Honorable Supreme Court, in interpreting section 154, using that one word, every information relating to a cognizable offence, if given orally, shall be reduced into writing. This one word shall and the word every caught the eyes of the Supreme Court. They deliberated on that and said, the policeman who is in a police station has no other option than to register an FIR. Okay, this is in the case of Lalita Kumari versus Government of UP 2013, 5 judges. This shall in Lalita Kumari was interpreted by the Supreme Court as shall. Where is the default, inbuilt default? No inbuilt default in CRPC. However, they fall back on IPC section 160. What does section 160 IPC says? If you don't follow a law, then it is a criminal act, offence. So Supreme Court took the cue from IPC 160 and connected section 154 subsection 1 default with section 160 of IPC, right? After 2 months of Lalita Kumari, in state represented by Inspector of Police versus N.S. Jnaneswaran, state, I think it is all getting recorded, so don't worry in writing. You can leisurely listen to that and write this thing. State represented by Inspector of Police versus N.S. Jnaneswaran, G-N-A-N-A-E-S-W-A-R-N, 2014 Supreme Court. Here also the Supreme Court has to interpret section 154, not 1, subsection 1, 2. What does 2 says? Copy of the information shall be given to the, to whom? Complainant. Here also the word used is shall. Question before the Supreme Court is whether this shall is mandatory or directory. Guess what the Supreme Court would have said? Not mandatory. See, 154 subsection 1 Supreme Court said this is mandatory. 154 subsection 2 Supreme Court said this is not mandatory, this is directory, because mere non-furnishing of that to the complainant will not have the same consequence of non-registration of FIR. Non-registration of FIR will directly have inroads into Article 21. Right? If there is a delay in registration, there will be a delay in investigation. Delay in investigation leads to disappearance of all the clues. This is so. Every shall in law is not shall, every may in law is not may, every and can be read as or can be read as and. So in this light, then coming to my lord's subject is commercial laws and arbitration. There is yet another interesting aspect. In commercial law cases also, can you file a written statement beyond the period? As we do in civil cases. Now in civil cases, written statement can be filed after 90 days also. Can you do that in commercial act cases? No idea? Any answer? One judgment of the Honorable Supreme Court is Messrs. SCG Contracts, Messrs. SCG Contract India Private Limited versus Chamankar Infrastructure Private Limited, 2019 Supreme Court. Supreme Court has distinguished between the provisions of section 148 as against the provisions of Commercial Court Act and said, here if written statement is not filed within a particular period, he is prevented from filing in a subsequent period of time, and court is also prevented from receiving it. So all the doors are closed. Now the Supreme Court has interpreted that you cannot expect the same amount of leniency that you have expected in Salem Advocate Bar Association case. So I am at a loss to say, because I am an advocate, that's all. I am just putting it before this August gathering, and it is for my lords to decide whether all shall or may in new BNSS. The intention of the Parliament, the public policy is, if there is a time scale, then that time scale will be followed such that people will get timely justice. That is the reason BNSS has introduced lot of provisions, time scales, and the time scales has to be interpreted. Okay, this is one fine point. Also read the judgment of Barun Chandra Thakur versus Master Bolu, 2021 judgment, where the Supreme Court, while interpreting section 15 subsection 1 of Juvenile Justice Act, where the word may is used, that is, in a preliminary inquiry by a Juvenile Justice Board, they may include a psychologist in that. This word may was lightly taken by the Juvenile Justice Board. Supreme Court said this may has to be read as shall, because the public policy involved in this is very significant. A child cannot be just like that made as an adult. So in all these slides, this law has to be interpreted, just leaving it, and we will go inside the act, right? Now, so time schedule is one thing, my dear. Then second is fast and efficient justice system. Third important aspect is electronic communication. What has happened is, now VC is rampant across the country, video conferencing. Second is involvement of audio, video, electronic means in the investigation, in inquiry, and also in trial and in appeal cases also. So there may come a day where the court will only have one person. Who is he? Yes. He will be sitting like a god in the temple. No pujaris will be there, no devotees will be there. We will all be having darshan from our home. Day may come like that also. This is the dream of the Parliament as envisaged in section 530 of BNSS, read with section 2 subsection 1A and I. 2 subsection 1A speaks about audio, video, electronic means, and 2 subsection 1 speaks about electronic communication, right? I will take you straight away to section 530 now. 530 of BNSS is the dream of the Parliament. It says trial and proceedings to be held in electronic mode. All trials, inquiries and proceedings under this Sanhita, including issuance, service and execution of summons and warrant. Subsection 2, examination of complainant and witnesses. 3, recording of evidence in inquiries and trials. All appellate proceedings or any other proceedings may be held in electronic mode, not shall. because the Parliament is aware of the limitation of this country. Parliament is also aware that the entire country is not well connected with the VC. But this may also can be read as shall in future, if the country is fully knitted with all this VC and all, right? Yes. One judgment by my Lord's Honorable Justice Nirmal Kumar, please note that. You can also produce it before your family courts. A great relief was given by my Lord's Honorable Justice Nirmal Kumar to the entire Tamil Nadu, family courts especially. Now my Lord has given a beautiful judgment. This is in line with section 530. My Lord had quoted Dr. What is the first judgment? Dr. Prafulla Desai versus State of Maharashtra, 2003. See the prophecy of judge who has written the judgment. 2003 judgment. My Lords had included all that in his judgment. Shri Lakshmi versus Anirudh Ramkumar. Shri Lakshmi versus Anirudh Ramkumar, where my Lords in 2024, 10th month, my Lords have held that a party can present an application in a family court, not physically, but through virtual mode. He can do everything, giving a quietus to almost a greater headache, where the family courts will always say that party should come and die there for everything, from the presentation till receiving of copy application. So this is in greater lines with the dream of the Parliament envisaged under 530. Then also write the another judgment of Anubhav Mittal and others of the Honorable Supreme Court. Anubhav Mittal and others versus State of UP and others. Here in this case, the Honorable Supreme Court has said, in lines with section 530, court should ensure that efficient VC has to be provided. This is a judgment of 2025. Now, whether all the proceedings should be done under VC means, the answer is, I am taking your attention to section 183, which was the erstwhile 164. What is 164 CRPC, my dear? What is recording of confession and statements? Okay. Now, taking into consideration the intensity of section 530, Anubhav Mittal, I said, Supreme Court said every process should go through VC. But the process under 183, please jot it very carefully, the process under 183, that is recording of confession and statement, which was the erstwhile 164, Supreme Court has given a direction that this recording of statement and confession under 183 BNSS, that is 164, should not be made in VC. CBI versus Mohammed Yasin, please jot, CBI versus Mohammed Yasin Malik, right? It is 4th April 2025 division bench. So 530 exception was carved out by the Honorable Supreme Court in CBI versus Mohammed Yasin Malik. No business of recording all this, statements and confession by the magistrate, right? This is the second thing, exception, right? Then another thing is, I told you that summons can be issued by electronic mode. In that also, section 35 BNSS, Supreme Court has once again carved out an exception that notice under section 35 BNSS should not be made by electronic mode. What is 35 BNSS, my dear? What is 35 BNSS? 41A notice, right? This is in the case of Satyendra Kumar Antil. If I say Satyendra Kumar Antil versus CBI, you can write it 5 times. Satyendra Kumar Antil CBI versus CBI 2021, Satyendra Kumar Antil versus CBI 2022, 23, 24, 25. See, 5 judgments are really pearls. Pearls, I mean pearl. You lawyers can earn if you download these 5 judgments, you can mint money. I am not joking honestly. As my Lord said in the morning, this Satyendra Kumar Antil says It gives various regulations regarding bail, regarding notice, when a person can be arrested by the police, when notice has to be given, what should be seen at the time of remand, how can a person be remanded by the judge if charge sheet is filed, if charge sheet is not filed, categorization of offences, all these Satyendra Kumar Andil is a CBI from 21 to 25, but in 25 judgment, the Honorable Supreme Court, it says 35 subsection 4, when such a notice is issued to a person, it shall be the duty of that person to comply with the terms, right? 35 subsection 3, notice shall be issued. No, in that Supreme Court says, in that, no, Satyendra Kumar Andil versus CBI, 25 Supreme Court, in that, there is an IA filed, which is called as State of Haryana versus Satyendra Kumar Andil. You should go to State of Haryana in CBI, Satyendra Kumar Andil versus CBI, and IA was filed 6369-1 of 2025. 6369-1 of 2025 IA was filed. That judgment is called as State of Haryana versus Satyendra Kumar Andil. In that, the Honorable Supreme Court has said, we do not go with the logic that all the notices and summons under BNSS as mandated under 530 should be issued, because 35, which is equivalent to 41A notice, there is no specificity that this notice should be sent to an accused person in electronic mode. So 530, we have already seen 183, they have carved out an exception that 164 CRPC or 183 BNSS should not be recorded by in VC mode. Like that, a notice like 41A notice under 35 now should not be served on him in electronic mode, because every policeman will say now, he will send something in my WhatsApp, God knows whether I have received or not, then he will come to my doorsteps and say, I have served notice on you, 41A notice, I am arresting you because you have not obliged that. So the Honorable Supreme Court, in all its sensitivity and wisdom, is carving out slowly what it has to carve out to protect the people, right? So these are all areas where the Supreme Court is proactive in carving out certain exceptions out of section from 530, all right? Then, what is more interesting? Yes, the topic is trial under BNSS, right? What are the, before getting into the trial, let us first understand what is a trial, when does the trial gets commenced? My Lord's registry has given me a box of chocolate today morning. I am having it in my room. If anybody answers 2 questions properly, then I will give the entire chocolate to you. Who wants it? Any students are here? Okay, I will ask you 2 questions. Question 1, where is the word case defined? We are dealing with criminal case, CASC, right? Where is the word case defined? CASC. In which law? Don't want chocolates? I will tell the answer. You don't want chocolates? The balcony. Bag of chocolate, my dear. I do not know how to carry that. Yes, the word case, Honorable Supreme Court in 1970, the Supreme Court says, a full bench of the Supreme Court says, the word case is not defined anywhere. You could have said this answer. What is the question? Where is the word case defined? What is the answer of the Supreme Court? Not defined in any law. However, in the case of Bimmappa, Basappa, Bhusanavar versus Lakshman Shivarayappa Samagowda. Can you repeat? I am not telling any mantra and all, right? Standing near this and this. Bimmappa, Basappa, Bhusanavar versus Lakshman Shivarayappa Samagowda. 1970 Supreme Court says the word case is not defined anywhere under the law. It has to be understood in the criminal parlance. A criminal case is a proceedings which either ends in a discharge or in an acquittal or in a conviction. This was the definition given by the Honorable Supreme Court for criminal case. We are discussing under criminal law. Having understood what is a criminal case, now the second thing is, when does a trial commence? there is no time. Had my lords given me one full day, then we would have had a longer discussion, right? I hope my lords invites me once again for a full day. You want me once again here? No? Yes. Yes. The Code of Criminal Procedure was of the year 1861. It underwent an amendment in the year 1898, then an amendment in 1973, then 2001, 2003, 2005, 2009, 2013, 18, lot of amendments, right? The word trial from 1861 until 2014, the word trial was not deliberated thoroughly by the Honorable Supreme Court, and it is in the case of Hardeep Singh versus State of Punjab, 2014 Constitutional Bench, the Honorable Supreme Court has propounded that trial commences after framing of charge. Right? This is one thing which I want to impress upon you. A trial commences after framing of charge. Now, framing of charges, as my lords had already deliberated here, previously framing of charge is one area where advocates like us can happily play for a very long time. A1 will file a discharge, it will get dismissed, go to the High Court, then the Supreme Court, it will take 10 years, then A2 will start the game, A3 will do that. Now the Parliament has mandated that such a framing of charge, such a filing of petition for discharge has to be made within 60 days from the date of committal proceedings, or that is with regard to sessions cases, or if it is a warrant case, from the date of receipt of free copies. Under section free copies is under section 207 CRPC, now it is 230. One nice introduction under 230 is, it has now become victim centric. Previously 207 free copies are given only to accused. Now 230 says free copies should be given to the accused and also to victim. Read one judgment of the Honorable Supreme Court, Rekha Murarka versus State of West Bengal 2019. This judgment has to be read in conjunction with Bhagwant Singh versus Commissioner of Police 1985. This Bhagwant Singh versus Commissioner of Police was the first of its sort where the Honorable Supreme Court has said a complainant has got a right to protest if his case was dropped. Whenever the case of the complainant is dropped by the police, then he has got a right to protest on that and file a petition that I had a case before you, you have dropped it willfully. This is in the case of Bhagwant Singh versus Commissioner of Police 1985 Supreme Court. What does this case say? Rekha Murarka versus State of West Bengal 2019, it says under section 24(8) of CRPC. What is 24(8) CRPC, my dear? Corresponding to 18(8) of BNS. What is it? A victim can engage an advocate of his or her own choice. Right? Why do you say all this now? 230 says a victim has to be given all the copies on which the prosecution relies. Right? If the victim at the outset before the trial commences, she or he has the bundle of copies along with the charge sheet from FIR, she or he will be in a position to protest that this is not the case I have given, or the investigation has went astray. So now provisions in BNSS right from section 173, that is 173 is akin to 154. 173 also says, previously 154(2) says copies of FIR should be given to the informant. Now it says to the informant or victim. This or can be read as and no. See, suppose Andrew goes and says, a girl is shouting from the top of the floor, I do not know what is this thing. Police may happily file a FIR for nuisance, but that girl would have got raped or killed there, right? Now somebody from the girl's family, victim's family, also should know what is the content of the FIR. So in that score, section 173 in the new BNSS says, copy of FIR should be given to the victim. 230 says, and 193 says, 193. What is 193, my dear, no BNSS? 173. What is 173? Charge sheet, filing a final form, right? 173 subsection 173 is akin to 193. In 193, there are mandate to the police that within 90 days, the police shall inform the informant and the victim what is the progress. This is one good thing in the new law. Then 193.8, which is 193.9 proviso, which is akin to 173.8. What is 173.8 of CRPC? Further investigation. Excellent. Previously, in one case of 1976, Devarapalli Lakshmi Narayana versus Narayana Reddy, 1976 Supreme Court. That from 1976, courts were under the impression that whenever charge sheet is filed and cognizance is taken by the court, court cannot order for further investigation unless and until prayed by the police. Now, 2019, read the judgment of Honorable Justice Nariman. Vinubai Haribai Malavya versus State of Gujarat. He says, this judgment, 3 judges bench, once again, he says, this Devarapalli Lakshmi Narayana is per incurium, a full bench declaring the judgment of another full bench as per incurium, because they have found that 2H relating to investigation was not discussed by the 1976 this thing. Investigation means it includes investigation and further investigation, and in Vinubai Haribai Malavya of the State of Gujarat, the Honorable Supreme Court has said further investigation court can order even after the court takes cognizance. This is in 2019. What has happened in BNSS? 193 subsection 9 proviso has taken cue from the Supreme Court judgment, and now they have stated if further investigation should be ordered by the police, they cannot do that without obtaining the permission of court. Why? Previously what will happen? One side court will be conducting a trial, and police pending trial, they will do the investigation from west to east. Court will be conducting the case from east to west. Now, this is also, this provision amendment is also a result of Vinubai's case, because Vinubai, the Supreme Court said, under 173.8 of CRPC, police can make further investigation till the end, till the termination of trial, pronouncement of judgment. Supreme Court said, no, police should take up permission, obtain permission from the court under the doctrine of ex positio contemporanea. Vinay Tyagi. What is ex positio contemporanea? That is, the contemporary laws, the position of the contemporary law in the country is, police had the habit of obtaining permission and filing charge sheet in cases of pending trial. Okay? Then, this is the time frame. So, courts are now governed under BNSS to ask for a discharge application within first 60 days. And from the date of first hearing, a judge shall frame charge and should not sleep over on the file for a very long time. Right? Now, what has happened is, the Supreme Court is aware that in spite of all provisions, courts will not do things like that. So, what has happened is, now the Supreme Court, I will just come to that relevant provision, that is 250. Now, the Supreme Court, section 250 speaks of discharge in sessions cases. Please jot down this judgment, Aman Kumar versus State of Bihar, 2025. Aman Kumar, A-M-M-A-N, Kumar versus State of Bihar, 2025. Honorable Supreme Court has kept the matter pending, want to give a pan-India direction as to why charge sheets are not framed in time in consonance with BNSS 250. So, a day will come when Supreme Court will declare whether this 60 days is mandatory or directory. Beyond that, it will be very difficult for us to do that. Yes. Then, I will also rely upon one judgment, Dr. Anand Rai, relating to 250. Dr. Anand Rai was a State of MP, and coincidentally, this judgment was delivered by Honorable Justice Sanjay Karol, and Justice Kotiswar Singh. Beautiful judgment by both my lords. This is a case relating to further investigation, 2025 judgment. Right? Dr. Anand Rai versus State of MP. In this case also, the Honorable Supreme Court was dealing with an application regarding 138 subsection 8 of CRPC. A lady was examined as PW1 in the box. After chief examination, after 8 years, she files an application for further investigation. Now my lord says further investigation can be done at any time, but not after 8 years you are cross-examined in a case of 498A. This is vindictive in nature. So further investigation should not be made like this. This is the case of Dr. Anand Rai. Okay. Right. We will come to the another part is, now accused can also appear in VC. All the witnesses can appear in VC. One novel aspect is section 336, my dear, 336 BNSS, a beautiful provision. See, as a trial court lawyer for a very long time, the case will get stagnated mostly because after the eyewitnesses are over, official witness part, many officers who had examined the case 10-15 years, they would have either gone to foreign, abroad, or they would have gone to meet the maker, because they would have laid the charge sheet by 60. We will be conducting trial when they are 80. So they would have went to meet the maker. That is one thing. 336 says now, whenever an official witness has to be examined, you don't search for that man who has done the part of that official work. Who is the successor, give notice to him. And let that successor be not dragged to the court. He can sit in a VC like this happily and do the job. So this is one excellent provision in section 336. Then coming to 349 of BNSS. 349. This 349 speaks about specimen, signature, handwriting and voice specimen. 349. Is there any law in this country to record voice sampling? Is there? See, previously we had one law which is called as Identification of Prisoners Act 1920, section 3, 4 and 5. It says you can take fingerprints, footprints, blood samples, photograph. If the accused is non-cooperative, use minimum force, because in the morning somebody was asking about torture and all. 1920 Criminal Identification of Prisoners Act says you can obtain all this from any person against whom a case is pending, which may entail in a rigorous punishment for more than 1 year. This is what the yardstick is. This 1920 Act was alive until 2022. 2022 criminal law amendment of this act came. Now it has included blood samples also in that, DNA materials. Right? One question was asked with my lords today morning regarding the credibility of DNA. Please read one judgment of Rohinton Nariman, Ravi versus State of Maharashtra, 2019. My lords have said today morning that if you have a DNA, it is more scientific and admissible to an extent of 99.999. The same words were used by Honorable Justice Nariman, Ravi versus State of Maharashtra 2019, where the court speaks about YSTR analysis. What is YSTR analysis? There are two chromosomes, X and Y. Suppose a woman who is a rape victim or a sexual assault victim, they take swabs from her, vaginal secretions. That secretions will have two ingredients. One is it will have the secretion of the woman also in the vaginal and the man's chromosome also will be there. So first of all, the DNA material will be taken and delineation will be made as to X and Y. Then this analysis will be made, which is called as YSTR analysis, short tandem repeat analysis. Now the Supreme Court says all these DNA analysis and the results thereof, the result is 100%. The reliability, as my lords have said, is 100%. Only thing where a defense can play some luck is chain of custody. DNA material chain of custody is broken. That is the only luck you can play with. Otherwise, Ravi versus State of Maharashtra is certain on that. Please read that also. Why I am insisting on that is, now the present BNSS says, section 176 says, DNA, whenever the offence is punishable for more than 7 years, DNA analysis is mandatory. It is good on 2 scores. One is, if the accused is not a real culprit, he will get rid of. And the victim will have true justice, because DNA materials will not lie. See, from the morning, my lords spoke here and I am the last to speak. Even if Chandru leaves the hall, Chandru will be alive here for 100 years. How? See, now lot of salivas I am just spilling without your knowledge. My hairs are dropping. My skin particles will be here. Any expert who comes here will found out after 100 years also, there is some particles of Chandru, he is here. Right? So DNA, the police in this country should get themselves equipped in such a way that, as mandated under 176 of BNSS, now if the offence is punishable more than 7 years, then forensic examination is mandatory. It is in the interest of both the accused and the victim. I will ask you one question, if there is any policeman. A man is accused of rape. Okay? Whether the examination of the man is very important or woman is very important, which has to be done at the earliest point of time. In a rape case, a medical examination of whom is very important, very imminent, has to be done urgently. On the man or the woman? Woman. Male. Why? See, both are equally important. Right? Both are equally important. A man will also have injuries. See, whatever injuries that she has sustained, in preventing the assault, she would have assaulted the man to the extent or intensity which she could have. Even a small child, 6-7 years old child, it will try to defend. By that small kuti fingers, it would have scratched. If you arrest that man at the earliest point of time, certain DNA material of the child or this man will be there. So both are very, very important in that score. Okay. Then coming to termination of trial. So my endeavor is to impress upon you is that trials are no more physical trials in the future. Smruti Tukaram Babade versus State of Maharashtra. You know that, no? What for it is? Vulnerable Witness Deposition Center. Smruti Tukaram Babade versus State of Maharashtra. 2020, Honorable Supreme Court has said, if you feel that witnesses are vulnerable, you set up deposition centers. Like that, now deposition centers is yet another dream of the Parliament. Witnesses will go to a deposition center, accused will depose from the place of custody or from his home, right? Judges will be there. So the dream of Parliament is all trials, all inquiries and all appeals should be done in VC mode. This is one thing. When does a trial gets terminated, my dear? My lord is not in the, he is not included in the game. No chocolates for him. Chocolate is only for others. When does a trial gets terminated? When does a trial, let us not think about the appeal. When does a trial gets terminated? If you read section 353 of CRPC, now 392 of BNSS, the trial gets terminated. See, reading the provisions of 353 of CRPC, it says, immediately after the trial is terminated, judgment is pronounced. It gives an appearance as if judgment is not a part of the termination of trial. It gives an appearance that after termination of trial, judgment is pronounced. This one provision of law under 353 is because this is very, very important. Why is, I have told you, further investigation can be made till the trial is over. Like that, 65B certificate, what is the corresponding provision now? 65B? 63. Am I right? Yes. 65B certificates can be filed till the termination of trial as per Arjun Pandit Rao Kotkar versus Kailash Kishan Rao Gorantil. Please take this one judgment, my dear. Read it threadbare. 2 Jains have written the judgment. One is Rohinton Nariman, my lords Rohinton Nariman, separate judgment. Another judgment is written by Justice V. Ramasubramaniam. Excellent judgment. You will understand what is electronic evidence, why such a certificate is warranted, why a mandate is made that 65B is mandatory. Right? Coming back, digressing for a moment, coming back to section 353 and 392 of BNSS, 353 CRPC, 392 BNSS, it is regarding termination of trial, pronouncement of judgment and termination of trial. Please read the judgment. The Code of 1861, when does a trial gets terminated, was answered by the Supreme Court after 200 years in the case of Sukhpal Singh Kaira versus State of Punjab, Constitutional Bench, 5 judges. Sukhpal Singh Kaira versus State of Punjab, 2020. Supreme Court has answered it. When does a trial terminate? Supreme Court has said a civil trial gets terminated on the pronouncement of judgment and not decree. Because decree is the speaking portion of the judgment, they are just culling out and typing it out. It is an administrative act of drawing a decree. If at all, no, if any brothers of Manipur is practicing before civil court, whenever a civil judge gives a judgment, you apply for a copy application, walk through that person, one man will be sitting there, right? He will tell you 1,000 times, judgment is ready, decree is not ready. Supreme Court says, a trial gets terminated on the pronouncement of judgment, civil trial, not on the pronouncement of decree, because decree is not a judicial act. They are just culling it out. No application of mind is required for culling out the decree. Coming to the criminal side, a criminal trial gets terminated on the pronouncement of acquittal, if it is an acquittal. If it is a conviction, Supreme Court says in Sukhpal Singh Kaira, if it is a conviction, then on the pronouncement of sentence and not conviction. You understand, my dear? See, court says, I convict you. I find you guilty, I convict. Thereafter, as my Lord says today morning regarding 313 is very important, I will also add one thing to you. Post conviction, you should definitely be in the court, plead to the court regarding suspension of sentence, regarding sentence, because every conviction will not lead to sentencing. Please read one judgment of the Honorable Supreme Court, Eliamma versus State of Karnataka, E-L-I-A-M-M-A, Eliamma versus State of Karnataka, where the Honorable Supreme Court says, post conviction, the court should decide and discuss why this man is not entitled for probation. The Supreme Court's intention is every conviction should not lead to sentencing. Conviction means prosecution has proved the case. You have found him guilty. There is another provision in CRPC 360 and 361 which says probate. And there are 2 judgments, Chani versus State of UP 2007, which says, and also read one judgment from my state, Gautaman alias Babu, 5 judges of Madras High Court, Gautaman alias Babu versus the government of Tamil Nadu and the Superintendent of Jail Coimbatore, 2014, my Lord's Honorable Justice PNP was also there, 5 judges, Gautaman alias Babu versus the government of Tamil Nadu, where they say that whenever probation of Offenders Act is in force in a state, section 360, 361 should not be invoked. You understand, my dear judges? You can still see even Supreme Courts and all other high courts, where in states probation of Offenders Act 1958 come into force also, they invoke a general law under 360 and BNSS, which should not be done, because general laws are like our poor mother-in-laws. Special laws are like our daughter-in-laws. Whenever daughter-in-law special law comes in, poor general laws should take rest. Understand? So, general alia specialibus non-derogant. So, Probation of Offenders Act, LEM State of Karnataka Supreme Court says, whenever a case ends in a conviction, the court should definitely decide why probation is not invoked. Failing which, it should be sent back. The Supreme Court says, send the case back to remand. So, this is one thing. And another one thing is, Shivaji Ankush Gaikwad was a state of Maharashtra. In this, the Supreme Court says, victim in every case has to be compensated. So, two things a criminal judge has to take care is, if it ends in a conviction or an acquittal, court should decide what has happened to victim compensation part, the injury suffered. My lords told in the morning, injury is physical, mental and to property also. So, any conviction, termination of trial should lead to two things, sentencing. Now, the Supreme Court in Sukhpal Singh Kera says, sentencing is termination of the trial, not conviction. Okay. I think I have, if you permit me for some more time, or my lords, is the time to wind up, my lords? Yes. Okay. I have not done much justice, but I am confident that from the morning you had enough torrential rain of wisdom through my lords. So, only some drizzle has taken place, and drizzles are always very good and gentle. So, if at all there is any error, my lord should forgive me. You can also teach me, I will also learn. And somebody was asking my number, I told that I will give. My number is 98433 22533. I am Advocate E.V. Chandru from Madras High Court. Any doubts relating to law alone is permissible, not doubts regarding this and all, right? Why this much of hair? So don't ask doubts like that. Doubts relating to law. If I know, I will text. If I do not know, I will have the courage to say, no, I don't know this. Right? Thank you so much. I once again, with all profound gratitude to my lords, the Honorable Chief Justice and other judges, Honorable Justice Nirmal Kumar Jay and Justice P.N. Prakash, my humble pranams. I am aware about my limitation of knowledge. I am a small dust in front of them. All gratitude to my senior who taught me law. Thank you so much. I love you all. You can remove this.
Oh, yeah. I think it was amazing.
Thank you, President.
Thank you very much, sir, for your valuable and empirical aspects of the Bharatiya Nagarik Suraksha Sanhita and its applications. Now we have reached the culmination of technical sessions. So now may I invite respected Sir Maisnam Loya Lakpa Maitei, Assistant Professor, Manipur Judicial Academy, to propose the vote of thanks.
Good evening, my lord, everyone. Respected dignitaries, esteemed resource persons, distinguished guests, and dear participants. On behalf of the organizing committee, it is my proud privilege to extend a heartfelt vote of thanks at the conclusion of this enlightening lecture series on criminal laws. I am deeply grateful to our eminent panel of resource persons in the technical session. Justice M. Nirmal Kumar, Judge Madras High Court. Justice P.N. Prakash, Judge Madras High Court. And a spectacular speech given by E. Chandrasekharan, Advocate and Special Public Prosecutor for the NIA at Madras High Court. Their valuable expertise and profound insights on the nuances of criminal trial management with special reference to framing of charges and the application of new criminal laws in trial have enriched our understanding immensely. A special commendation is due to the Honorable Judges of the Supreme Court of India, the Chief Justice and Judges of the Honorable High Court of Manipur, the Director of the Manipur Judicial Academy, the Advocate General, the Chairman of the Bar Council of Manipur, the President of the High Court Bar Association of Manipur, and the President of the All Manipur Bar Association for their gracious presence, guidance, and encouragement. I also extend my sincere appreciation to the organizing team, whose tireless efforts and meticulous planning ensured the smooth conduct of this program. To all participants, members of the bars, and attendees, your active involvement and enthusiasm have made this event truly successful. Finally, I thank each one of you for being part of this journey of learning and dialogue. May the knowledge shared today continue to inspire and guide us in our pursuit of justice. Thank you. Jai Hind.
Thank you, sir. So anyone from the online attenders, so if you have any questions regarding these technical sessions, sorry. Okay, Lord, sir. Thank you. Thank you, everyone, and especially for making this technical session more beautiful and more meaningful. And with the gracious permission of their lordships, we formally conclude today's technical sessions. And thank you all the participants for your esteemed presence and active participation. And now I would like to make an announcement that we have a cultural program. So all the participants, so kindly reassemble at 5. So please, and after this, and we have arranged the tea party for all of us. So kindly join the tea party. Thank you all. And all the participants through online mode, so you can log out. Thank you for your participation on this lecture series. Thank you all.